Yes.
Original side mentioning.
Yes, well, of 2018, madam, was that it will be listed on June. But it has not been appeared. It should have been.
It will appear in the next year.
Madam,
Come on the next year. On the reopening day, come on the reopening day, it will appear in the list. It is testamentary suit or ordinary suit? Testamentary suit. Testamentary suit will appear on either Tuesday or Thursday. So after next year, in the next year, it will come. Mention next year.
May I seek your lordship's kind leave? I'm mentioning upon notice, your lordship, just for your lordship's kind leave to file my written statement, additional written statement. They've amended, plaint had been filed. We received it on 20th November of this year.
Let it appear in the list. Let it appear in the
Your
list.
lordship, this is within, we went to the master says that a leave from your lordship is required. So
Let it appear in the
file
list. I have to check how many days we have spent.
No, we received it on 28th November, your lordship. We filed it
come in the
within
list.
30 days.
कल के दे दियो.
Your lordship, can you permit to mention,
Lordship, yeah, this.
Yes.
Which matter?
In the Marco Polo.
Tomorrow, it will come in the list tomorrow.
Tomorrow.
Permitted to mention a testamentary suit for inclusion?
Next year.
Your lordship, you can
Come on the next year.
May I have
It will
your
be
lordship,
misplaced.
may I have your lordship's leave to mention a matter, lordship? In this matter, I am appearing on behalf of the official liquidator. I am praying only leave to file a report, lordship, in this matter. Only for
Report दिखाना.
I'm grateful.
May I be permitted to mention this matter for withdraw the original will. The matter withdraw the original will, my lord. The matter was.
Let it appear in the list. Then it will be checked. Come in the second half better. Not mentioning. I will take it up.
Commercial division, item number 1 to 4.
But in item numbers 1 to 4, I am the plaintiff. It is my application which is presently pending. There is an order of injunction. But my lord, we were trying to settle the matter. Talks of settlement.
You are the defendant.
Talks of settlement are going on. My lord, I'll humbly submit that if this matter could be kept in the month list of February. Talks of settlement has been going on for some time. If it fructifies, my lord,
on prayer of the learned counsel for the plaintiff, suit is adjourned to in which?
My lord, month list of February, my lord. We'll get the entire January, my lord.
14 February.
I am extremely grateful to my lord.
Item number 5. Pestocon Engineering Industries Limited and others versus Genco Projects India Limited and others.
File my affidavit in opposition, my lord.
What is GA6, JCOM 6?
GA6 is an application taken out by the defendant for extension of time to file written statement after transfer of the suit to the commercial division. Initially, my lord,
GA6 is my application, your lordship, for extension of time to file my written statement. My lord, within 120 days from the date the suit has got transferred to commercial division.
Yes, you have right that.
Yes, my lord, 120 days is still there. It will expire on 28th of December 2024. I am within time, your lordship. Earlier, my lord, what happened? My lord, there were applications filed because the suit has become undefendant when it was in the ordinary list, ordinary jurisdiction, your lordship. But thereafter, it got transferred to the commercial division. My lord, the bone of contention before your lordship, which my learned friend raised on the earlier occasion.
What is your objection, Mr. Mukherjee?
My lord, objection is, my lord, the suit was instituted in 2016. Writ of summons was served, my lord. Thereafter,
your WS is ready?
My lord, WS? Yeah, my lord, ready.
My lord, may I just indicate, my lord? Thereafter, GA numbers 2 to 5 all were filed by my learned friend, my lord, for recall of an order by which the suit was put as on ex parte board, my lord. Thereafter, my lord, that application was dismissed for default. Thereafter, they filed another application for recall of the
Where are
order.
these orders?
My lord, I have filed their affidavit in opposition. Kindly takes up my affidavit in opposition. The orders start from, my lord, page number 9. Kindly sees, my lord, page number 9 is an order of 25th of July, by which it was, my lord, recorded that the writ of summons was served and they had neither entered appearance nor, my lord, they had filed a written statement. So, my lord, it was kept as undefended suit. Thereafter, my lord, page number 10. My lord, kindly sees, this is GA number 3. This GA number 3 was taken out by the defendant, but they were not present. So, my lord, by an order of 28th of August, my lord, their application was for dismissed for default, my lord. Thereafter, my lord, they filed another application, which is of which is at page 11, my lord. This is a substantial order, my lord, of 4 pages, by which, my lord, this application was filed in August 2023. My lord, kindly turns to, my lord, page number kindly comes to, my lord, page number 13, my lord. Second last paragraph, my lord records, defendant has filed application for extension of time to file written statement on 16th of August 2023. And in the said application, defendant paid for 4 weeks' time. In the meantime, the said application also dismissed for default. Defendant filed another application for restoration. This court had inquired from the learned counsel for the defendant whether the written statement is ready or not. But the counsel for the defendant, in his usual fairness, submitted that the written statement is not ready and prayed for further time to file written statement. This court finds that the application for
All right, that's in it.
my lord, another
This application is on behalf of defendant number 1.
defendant number 1, my lord, defendant
One.
number 2 and 3 have not been appearing. One more ground of objection I would like to take, my lord. What they
Just a
had,
minute, just a minute.
my lord.
Did a call order this?
This is finally decided by the single bench, by the previous bench.
Yes, my lord, but that is in the ordinary division, not in the commercial division. And my lord, there are judgment of Supreme Court which says that even a suit which has become ex parte in the ordinary division, as and when the suit is being transferred to the commercial division,
No, whatever
the
that
new
might
period will start.
whatever that might be,
My lord,
you should prefer an appeal against this order.
my lord, there is no need to prefer an appeal because no, we have preferred a recall application. My lord, kindly sees the page 15 of their opposition, your lordship.
Yes, that order, page
No.
15, the order is there, November 15, 25, 2024.
Yes, your lordship.
In that
My
order,
lord,
it
that
was
is a recalling
or-
application.
observation of the court is that order was passed in non-commercial division.
Yes.
Now this court cannot pass any order sitting in commercial division.
Right.
Now, if you are aggrieved with this order,
No, I'm not aggrieved anymore because the leave has been granted to me. Kindly see, my lord, accordingly filed by the defendant is dismissed. However, the dismissal of this application will not debut. So, my lord, there is no way.
liberty was given to
My
you.
lord, I do not need any recall as of now. So, a fresh
Who will
application.
submit? You or
My lord, I am submitting, your lordship. So, my lord, I do not need the recall as of now because today the time limit is there with me. As on the date, I am moving this application before your lordship. And
what time limit?
my lord, 120 days.
What the section says?
From the date it has got transferred.
Is it this much or something more?
My lord, let us come to section 15.4. My lord. My lord, kindly sees.
I'm ready. Be prepared.
Your lordship, I am ready. Commercial act kar dena.
Why he will give you?
এখান থেকে দিয়ে
He is my friend, your lordship. That is why.
এখানে আছে section 50.
My lord, yes.
No, I'm always there to assist, my lord.
Yes. My lord, 15.4 says the commercial division.
Accent, Judge.
Some riders are there.
Whether the commercial division or commercial court, as the case may be, may hold case management hearings in respect of such transferred suits or application in order to prescribe new timelines or issue such further directions as may be necessary for the speedy and efficacious disposal of such suit or application in accordance of the Code of Civil Procedure, provided that the proviso to sub-rule 1 of Rule 1 of Order 5 of the Code of Civil Procedure shall not apply to such transferred suit or application, and the court may in its discretion prescribe a new time limit within which the written statement shall be filed. That is why, my lord, there are judgments which says that, my lord, Order 1 of Rule 1 of Order 5 is, my lord, merely a directory and not mandatory. In respect of, my lord, transfer of the suit from ordinary division to commercial division.
Show me the judgment.
Yes, my lord. My lord, may I place, my lord, and here in this particular case, your lordship, the suit has become undefended when, my lord, it was pending before the ordinary division, and thereafter, my lord, it got transferred to the commercial division, and, my lord, the new time limit was given, my lord, for filing of the written statement. And it kindly comes to paragraph 8, 9, 10, 11, 13 and 14. May I read out paragraph 9, your lordship? Six and 9 both says,
Provisions of this act, sub-rule 3,
my lord, rule, yes,
shall apply to those procedures not able to find that.
yes, my lord, I found that.
Shall apply to those procedures
Yes.
that were not complete.
Provisions of this act shall apply to those procedures that were not complete at the time of
Yes.
transfer.
There is a Supreme Court judgments are there where explained where written statement has not been filed,
My lord,
that will continue to apply.
my lord,
In case written statement is refused and finally it is decided, then the question is whether it is complete or not. What will you explain?
yes, I have submitted a judgment with your lordship which says that even a suit which has become ex parte pending before the ordinary division, when it is transferred to the commercial division, the new time limit will apply. Well, kindly come to paragraph 6. It starts from paragraph 6, your lordship. Therefore, the trial court passed an order dated such and such to the following effect. The defendant number 3 and 4, in spite of service of suit summons, failed to appear, and defendant number 1 and 2, in spite of giving opportunity, failed to file their written statement. Hence, the suit proceeded ex parte against defendant number 3 and 4 and without written statement against defendant number 1 and 2. Thereafter, kindly cease. 7 onwards, my lord, 2018, District Judge Jalgaon was designated as the commercial court in terms of the Commercial Act, and the suit pending on the file of the Civil Judge Senior Division was transferred to the commercial court. After transfer, the defendants who were the appellants therein moved 3 applications respectively for condonation of delay, recalling of the order of no written statement dated such and such passed by the defendant number 1 and 2, setting aside the order directing the proceeding to go on ex parte against defendant number 3 and 4. Same like ours, your lordship. Now kindly comes to 8. The commercial court rejected all the 3 applications by an order dated such and such on the basis of the proviso of Order 8, Rule 1 of the Code of Civil Procedure. The said order was affirmed by the High Court by an order impugned in this appeal, forcing the defendants to come up with the above appeal. Now, my lord, there is no dispute about the fact that
I've
at the
got it.
time,
Mr. Mukherjee, reply tomorrow.
My lord, may I reply now?
Have you got any judgments?
Yes, my lord.
To me?
My lord, I'm drawing inspiration from what had fallen from my lord, that procedure was complete. Kindly look at this judgment, paragraph number 6 that has been placed, my lord. Here it was marked as ex parte, but there was no application before the civil court, the ordinary civil court, for leave to file written statement. Kindly see paragraph number.
well, there were recalling applications
May I?
before the ordinary civil court.
May I? Kindly see, my lord, paragraph 7 of the judgment that has been placed. The suit was transferred to the commercial court. After transfer, defendant numbers 1 to 4 who are on the appellants herein moved 3 applications respectively for condonation of delay, for recalling of order, and no written statement dated such and such. So there was no recalling application before transfer. Here, my lord, there was a recalling application before transfer, and by a 4-page judgment, my lord, the conduct of the defendant has been discussed in details, my lord, and thereafter, my lord, that right has been closed. So once the right has been closed, my lord, so far as the procedure with regard to filing of written statement, my lord, is complete. And just like, my lord, section 15 subsection 3 says, my lord, that those which are not complete, new timelines can be set. Even if, my lord, for the moment presumes that they may get a fresh lease of life after 6 years, just because of transfer, they get a fresh lease of life to file
Come
written
tomorrow with your judgments.
my lord, I'll do that.
I will also check.
But tomorrow is a little difficult. Can it
my
be
lord,
on Monday, my
Then
lord?
after vacation.
Very well.
My lord, the
January.
Supreme Court decision has also been followed by this honorable court, my lord.
3rd January.
I'm extremely grateful to my.
Of course, if it is rejected, there is no question of allowing. If it is allowed, you will get time lease. Because it was filed. It will be assumed that in this application, date of filing the application will be counted.
My lord.
So that will not prejudice you. Even though it expired on 28th December.
Yes. Supreme Court and this honorable court, my lord, Justice Sarkar has also, my
Some
lord,
other
stated
Supreme
when
Court
the
judgments
my
are
lord,
there.
suit has become ex parte, thereafter, my lord, new time limit starts.
My lord, kindly record that I filed my affidavit in opposition.
Affidavit in opposition, we kept in filed by the plaintiff, we kept in record.
My lord, in that case, if your lordship is, my lord, adjourning it, my lord, in the meantime, may we file our reply?
My lord, hearing has commenced, my lord.
Very well, my lord.
No,
I don't need to, my lord.
Wouldn't be proper.
It's only point of law. Fact is known to all.
No, yes, fact is known to all.
Hard in part adjourned to 3rd January for further hearing.
I'm grateful to my.
Fact is very simple and very short.
Absolutely.
There is no dispute on factual issues.
No. The only point, my lord, if my lord, it has become undefendant or ex parte, whether that
Pending
right,
or not.
yes, whether, my lord, the time limit starts or not.
Interpretation of pending proceeding. This one.
So another question, my lord, whether transfer gives an absolute right to the defendant to file written
Your
statement.
lordship, I am being told by my junior, my lord, 3rd, my lord, there is some difficulty. If your lordship keeps it, my lord, any day, my lord, thereafter, from 6 onwards, your lordship.
8 January?
8 January. Very good.
I'm grateful to.
8 January. Raghav.
8 January. Deeply obliged, your lordship.
Item number 6 is Wind Holiday Tours Private Limited versus Air India Limited.
Please, Your Lordship, I am appearing for the plaintiff and the petitioner. My Lord, Your Lordship was pleased to hear this matter extensively. This is on the point, my Lord, chapter 38. My Lord, one document we had shown where the bills have been acknowledged by Air India, and my Lord, the amount has also been acknowledged. Lord, Mr. Rajashri Dotto was in reply.
Mr.
He had made submission of today.
After vacation.
Praying for adjournment, he could not come to court, my lord.
কবে করবে?
After vacation, any day, my lord.
My Lord, we have filed our notes. I'll only beseech your Lordship.
10 January.
10 January will be here, my Lord. The only difficulty, my Lord, we have filed our notes. So if, my Lord, after this, my Lord, Mr. Dotto makes any submissions and
You are at liberty to file.
I'm very deeply obliged. Very deep.
Adjourned to 10 January. On prayer of the learned counsel for the
Defendant.
defendant. Hearing is adjourned to 10 January.
Deeply obliged.
Item number 7 and 8, Calcutta Commercial Bank
I
Limited
heard it
versus
extensively.
Pradeep Nahar.
Question is whether the mortgage, redemption of mortgage and addition of party.
Yes, there are two things, your lordship. First of all, the mortgage deed, no one knows where it is. So it's a fight between the court liquidator.
Two issues
and
are there. First issue, whether you have a right to redeem the mortgage.
Yes.
That is to be decided. Now, if it is not decided in your favor, then no further question comes. Still, administratively, it is to be seen why from the custodia document is misplaced. That is one thing. Second thing, once your right is recognized, that is redemption is recognized, then we have to follow a different procedure in the sense making an extensive search.
Or
That
what
should be
can be
judicial.
done is, if your lordship directs, we can get the certified copy and that can be treated as the
Discharge of mortgage,
original. Yes.
redemption.
Now I have got the written notes of argument ready.
File it.
My lord will pass the order as per your
Today
lordship.
I have some difficulty. My
Any day, your
PA
lordship.
is not there. Let me fix-
My lord, may I-
Also, I am submit our written notes.
My lord,
our
question.
argument with, that is with us, my lord, and also make submission, because I have not submitted on that point, my lord. My lord, I have the right to redemption first, my lord, but I shall show section 57.
Yes, you have filed your notes of argument. I'll consider that.
My lord, kindly see the last order, my lord. My learned friend wants to file written notes disposal. Kindly see the last order. He should. Kindly see the last order, my lord, that the report submitted by the official receivers, Calcutta, dated so and so, the matters will appear on the list for further hearing of the applications. Exception, if any, in the meantime. Leave
Report
is-
আছে?
Now, my lord, report, we have taken exception to the report, my lord, but kindly allow us
Where
to.
is the report?
Yes. Kindly see the report.
No, report is to be seen first.
Yes. So we should assist rather than, my lord, filing of notes.
I
This-
cannot allow you to file written statement exception against this because this is to be served upon this court first. This is to
Yes.
be placed in the record. Unless I pass order, how can you get a copy of this?
No, no, my lord, last order says so. Kindly see the last order.
Is
Sorry.
it there?
Yes. আমাকে একটু আমার মতো একটা minute
Shall make inquiry and report. That was passed on 20th September. Subsequent order was there.
Yes, 20th of September, 20.
Yes, 20 report was
report-
called for.
No, the report is submitted by the official liquidator High Court, Calcutta, dated 19th of September.
That is not order of 20th September.
Not ordered.
No, no, no.
We have got the
Folder থাকে।
the 20th September. Kindly see the order we have got.
20th September order is that copy of the report may also be sent to the registry original site. Registry original site shall make inquiry.
That's the earlier order probably. Thereafter, একটা staple করা নেই মানে
Thereafter, report was given.
No, previously 12th September,
that order is there.
no report was placed. That is noted here.
19th September 24. He is
My lord,
given
kindly
the
see
report.
the last order we have received from the website. Kindly see this.
He has submitted the report.
Yes, it is. I have this order.
No,
And he says that it's the
the
it
report
can't be traced out.
Please, Mr. Bose,
Fine,
we have
fine,
not
fine.
assisted. Please, I have not.
Oh, exception is there. Exception, leave it. Yes,
That's why, my lord. Why, Mr.
yes.
I will not submit something which is.
I know. And that's why I'm missing it.
No, no,
We have
Now,
filed our-
report says it is missing.
no, report. No, so we have taken an exception to this. Kindly see the, with all humility, my lord, this report has been submitted. There should be some desire to assist the court. Now, if the report is not there, he should pray for, as has fallen from a learned friend, my lord, appearing for one of the parties, Mr. Bose. If the report is not there, he should pray for something. Kindly see what he has said.
The learned,
My lord, may I file, my lord, two exceptions to this, my lord? Kindly give. Allow us.
give the exception.
Yes, yes. Leave is given. I will serve.
আমাকে একটা copy দিও দাদা।
সবাইকে দেবো ভাই গিফটটা নিয়ে
I am in difficult. The most difficult situation is for me.
Understand?
মেবি সেলফ ক্রিয়েটেড
No, 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 not.
Now
that.
এটা
It is between you who have created the problems. Between you and him.
Mr.
And it-
Bose is shifting the stand.
Yes, because you want to grab my property.
One said.
how
that-
many of exceptions?
But two, because it's GA11 and GA31. Two exceptions, my lord, because
Exceptions filed on behalf of the official liquidator be kept in the record.
my lord.
Now, এইভাবে লেখো exceptions filed in GA3 of 23 as well as in GA1 of 23 on behalf of the official liquidator be kept in the record.
Not filed by the applicant.
Written notes of argument filed on behalf of the petitioner be also kept in record. Report of the official liquidator was directed to be sent. Official liquidator dated 19/9/24 was directed to be sent to the official receiver. Yes. Directed to be sent to the learned registrar original site in terms of order dated 20th September 2024 with further direction to make an inquiry. Full stop. The learned registrar original site shall make an inquiry and submit a report on or before the returnable date. Fix the matter on 14 January for further hearing.
I have also submitted my written notes of argument.
A written notes of argument is also filed on behalf of
Applicant in J3, defendant.
the defendant, Pradeep Nahar. Let the same be kept in record. Next, I will reserve it for order.
May I only pray for instead of official, may High Court, my lord, of High Court official liquidator. Instead of official liquidator, may it be my
High Court official liquidator liquidate. High Court official liquidator liquidate. Next day, I will reserve it for order and I will pass
Yes,
necessary
yes,
order.
because I'm getting tousled in the fry pan like this.
That's a good thing.
কড়া বেশি হয়।
So next week, my lord, I shall orally submit, my lord.
I will close the argument and reserve it for order. But before that, let me have a report from the registrar original side. I need a report, something in black and white.
57 of the transfer of property.
Come on the next day, mention it in your notes of argument. That's all.
Item number 9.
My lord, with your lordship's leave, item number 9, I am appearing for the plaintiff. This suit was transferred to the commercial side and thereafter it is appearing. While it was in the ordinary list, my lord, this was an undefended suit.
Trademark matter.
No, my lord, no. Goods sold and delivered, price unpaid.
Where is the witness?
No, my lord, your lordship had not directed me to bring my witness.
Judge's brief?
Judge's brief also, my lord, there was no direction. So if I may file them. And only one thing I will point out. One thing before your lordship passes the order. After transfer, my lord, perhaps, my lord.
Statement of truth.
No, all those are done. But after the transfer, a fresh writ of summons, whether it needs to be served or not, that your lordship will consider. Because they have a fresh, I don't know whether that's an unfettered right or not, but they have a right to file written statement. So any report from the department, my lord, whether it's been served or not, and thereafter I can file my judge's brief.
File fresh writ of summons. That would solve the problems.
My lord, my lord.
Fresh writ of summons may be filed as submitted for service of writ of summons upon the defendants. Let the matter appear in the list on 24th January.
Grateful.
Item number 10. Union of India Ministry of Railway and another versus MS Howrah Gases Limited and others.
Defendant, your lordship.
Your lordship,
What is the status of the suit?
your lordship, the formalities have not been completed, your lordship.
Statement of truth?
Yes, your lordship.
Lordship, if the
So your
statement, the
lordship will
formalities
kindly
are not completed, I cannot file my written statement to the amended plaintiff because your lordship knows in the Commercial Codes Act.
You file an application just before 2 or 3 matters earlier. I was hearing this point.
Lordship, the difficulty is they will have to serve the plaint to me along with the annexures. I'm
The
fortified
learned
by a
counsel
decision
for
of
the
your
defendant submitted
lordship.
that copy of plaint is yet to be served. Writ of summons was served.
Writ of summons was served in the earlier suit, but in the Commercial
Copy
Codes
of
Act, they will
plaint
have
was
to
not served
disclose-
after transfer of the suit to commercial division.
Yes, your lordship. They will have to disclose
And
all
on that
documents.
ground, raise leave to file appropriate application allowing the defendant to file written statement. Full stop. Amended copy of plaint may be served.
Your Lordship will kindly grant us some time to complete the formalities, Your Lordship. The statement.
The learned counsel for the plaintiff also craves leave, prays for accommodation to file statement of truth, disclosure of document and other file affidavits. Leave is granted. Let the matter appear in the list on 27 January.
Your Lordship, may it be in February, Your Lordship?
No,
So that
commercial matter.
Your Lordship, if Your Lordship kindly considers, on the 17th of September, there was a direction by Your Lordship to transfer the suit to the commercial division. Your Lordship, there is a view which says that the written statement has to be filed within 120 days from that day of the order. Now, the difficulty is unless and until I'm served with a copy
That
of
I have
the
noted.
plaint, I cannot file my
I have
written
noted that in my order.
statement. Yes, Your Lordship.
That
sure.
will help you in future.
Very well. I'm great.
Item number 11, Farm Developments Private Limited and another versus State of West Bengal and others.
Issues
Yes, I thought possible, Lordship, it's getting
after vacation. Come after vacation.
Lordship, kindly makes it
because
Because I have no PA today. I have to do it myself.
Lordship, I'm also handicapped. My clerk is getting married. He
I
is
do
not
not
coming
have
out.
I
don't have
any
my
issues, but
papers.
the only problem that happened was yesterday the matter was conclusively heard before the Supreme Court, and in that when the in the midst of the hearing it was asked what is the status, and it was said it's been kept as for framing of issues tomorrow.
Judgment has been reserved in
Judgment has
before
been
the
reserved.
Supreme.
I just want to file it whether Lordship fixes it or not. It's
3rd January?
Very well, Lordship. We'll let you.
3rd January it will appear.
Very well.
Or I can fix it on Monday also.
yes, I can do that.
Monday, then it
Monday,
will go
Lordship. I just want to file it. Lordship can frame it.
Third January, Lordship is
Because since
after
it was
vacation.
said on open court, I just want to file that suggested issues.
File it. You may file it.
Yes.
Suggested issue filed by the learned counsel for the plaintiff be kept in the record.
Yes, that is all. That is, I am just giving a copy here and I am just filing it here.
একটা কাজ করো লেখো suggested issue filed by the learned counsel for the plaintiff be kept in the record. The learned counsel for the defendant craves leave to file suggested issues. Leave is granted. Let the matter appear in the list on 23rd December for framing of issues.
Very well.
Lordship,
I'll give them a copy.
copy will do.
Copy will help you nothing because the issues I can just throw it away.
Yes,
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 Lordship.
exactly.
Lordship will.
Exactly so. This is just a formality, nothing.
23rd.
Item number 12, Evergreen Marine Private Limited versus Electro Steel Castings Limited.
Here for the defendant, my lord. And on the last occasion, documents were disclosed.
Who is the defendant?
My lord, I am the
My lord, I
defendant.
am appearing for the plaintiff, my lord.
Yes.
Lord, there was one prayer that I was making. Inspection to be completed, my lord, pursuant to my lord's last order. My lord, I was saying that if the directions could be given for admission.
Withdraw
denial
list of documents file for a correction.
Yes, my lord. That is, my lord, still pending, my lord. Praying for some time to correct the list of documents, my lord.
How long would you take? How long would you drag the
My
matter?
lord, a week. No, my lord, I don't wish to drag the matter, my lord. I am the plaintiff, my lord.
On
Just
prayer
a
of
week's
the learned
time.
counsel for the plaintiff. The suit is adjourned to 9 January for compliance with the order dated 28 November 2024.
Grateful, my lord. Grateful, my lord.
Item number 13, Sigma Inc. versus the Indian Record Manufacturing Company Limited and
Is
another.
it for issues, framing of issues? Who is the defendant?
Item number 11 is suggested issues. They print out.
Oh, that is in the 11.
So 13 is my application.
I am appearing
But
for the defendant number 1.
It is a very formal amendment, my lord. If your lordship is pleased to take the
Which is the amendment application, 2 or 4?
GA4, my lord.
What is 2?
The GA2 is my application for disclosure of additional documents. In commercial suit, my lord, at the time of filing of the suit, my lord, there were certain documents which are not in my custody, which I have recovered. That application has been filed for additional documents.
So far as 2 is concerned, exchange of affidavit?
Everything is complete.
Everything is complete.
Amendment, my lord, in this application
Is that
Amendment
page-
for?
My lord, at page 29, if your lordship please to take up the application at page 29.
Oh, that one.
Yes, my lord. Name has been changed, but
Master
now the
summons to the-
statute has been repealed and the fresh statute has come in. Only that much.
That may be allowed.
You are for?
I'm for the defendant number 2. My lord, I may be allowed to file my written statement.
But it's a commercial suit.
No, my
It's
lord,
the
twice
time,
it was
time
amended.
has
Twice,
lapsed.
first it was amended the name of my defendant number 2.
That will,
And second, it was amended with regard to the act. Well, now I have to file my written
no, there's no change in the merit or in the matter. It is only change in the cause title to the extent it was Kolkata Port Trust. Now it is Shama Prasad Mukherjee Port Trust.
That's right.
Now you
The
are
name-
defendant number 2.
I'm the plaintiff.
Defendant number 2. The name is something else. Who will file the written statement?
No, in 2018, the name
When
was
do you
not
like
something.
to file the written statement?
Lordship can give direction after direction.
Well, it's a commercial suit of 2018.
Is there any cause for filing written statement as of now?
Practically, there is no claim against me. But I
As of now, is there anything, any scope to file written statement?
scope in the sense it is amended twice. My name of it is amended.
Till today, it is pending for amendment. Unless this amendment is done, that cannot be.
Yes. Correct. Correct.
Let the amended plain be served upon you.
Yes, ma'am. Yes.
GACOM 4 of 2024 is filed by the plaintiff. Praying for amendment. Have you checked the spelling? SYAMA.
No, it is SYA. In the notification, it's SYA.
SYA,
Yes, my lord.
not SH.
No, my lord. If your lordship is pleased to take up page 9,
That's why you correct. It's correct.
page 9, my lord, of the application. That's the gazette notification. My lord, the name in the second paragraph in the first schedule, part one,
SYAMA.
SYA.
Gulam?
ये product Satan is filed by the plaintiff praying for amendment.
Amendment of the cause title in view of statutory changes in the name of the plaintiff in the defendant number 2. The amendment is formal in nature. Let prayer A to C of the master summons be allowed. Amended plain may be served upon the defendants, whereupon the defendants shall be liberty within statutory period to file additional written statement. Got it?
120 days.
There must be meaning in submission. Let the suit appear in a list. Not 120 days, it is 30 days.
30.
After 30 days, you have to file application. 22nd January.
Along with GA2, your lordship. Along with GA2.
Along with GF. Is it?
was disposed of.
4 was disposed.
Yes.
GA2 is
Correctly, the J4 stands disposed of. Along with GA2 of 23.
grateful.
Oh.
Item number 14,
14, I'm for the
Orient
defendant
Exports
number,
Private Limited versus Jail.
defendant
Real
number,
Dash.
defendant number
Dash.
1, 2 and 3, my lord.
Who is the plaintiff?
My lord, plaintiff is not appearing for the last couple of occasions, my lord. Lordship was supposed to dismiss the matter.
None
yesterday.
appears for the plaintiff. Full stop. On 22nd November 2024. As well as on 11th December 2024.
My lord,
None appeared for the plaintiff. That this would be dismissed for
my lord,
default.
we have on counter claim that may be continued, my lord.
The
Counter
plaint
claim.
may be dismissed for default. However, the counterclaim shall continue to be heard.
Grateful, lordship.
Or better, without dismissing it, let it be heard ex parte. Because that part cannot be dismissed. Let the suit be, let the counterclaim be considered undefended against the plaintiff.
Get.
Is there any written statement against the plaintiff?
No.
Against your counter additional?
I have filed written statement with counter claim.
Is there any additional written
No,
statement?
no, they have not filed. Long back we have filed.
আরেকটা কাজ করে দাও ওখানে লাইনটা কেটে দাও none
There was a
appears for the
direction, my
plaintiff
lord.
on previous occasion none appears দেখি প্লেনটা দেখি
The written statement was filed on 2019, my lord.
Your claim is 25 lakh.
No, my lord. My claim is in the counter statement is around 75 lakhs 90,000.
Written statement.
Page 30 of my written statement. Two columns. Written statement. Two volumes. There are two volumes, my lord.
I need the first volume only.
First volume, page 30.
75, 90,000. 75 lakh 90,000 with interest. Let this counterclaim be hard ex parte against the plaintiff, as it appears that plaintiff is not interested to proceed with the plaint case.
Date production.
ডেট বলে দিলাম কবে হবে?
No, my lord.
রিটার্ন না ডিসমিস হবে না, কাউন্টার ক্লেমটা তো প্রসিড করবে। The suit will appear in the list for hearing counter claim on 27 January.
My lord, can it be in the month of February, my lord?
7 February.
Date production. Sir.
Item number 15, Saurabh Gupta versus Royal Sundaram General Insurance Company Limited and another.
Did you finish your argument?
Hopefully.
And for defendant number 1, your lordship.
Your basic argument is that there is no case against you. Let the case be decided between the other parties.
They don't have a cause of action against me.
Whatever that may be,
Yes.
it is between them.
Yes. Whatever it is, it's a claim arising out of an insurance policy. I acted as an agent for the insurer. I can't be liable for any claim. Number, there was an aside to this. There was an allusion in the plaint or even in their evidence to the effect that whatever money had been received by them under the insurance policy had been adjusted by us wrongfully. They have not specifically incorporated a prayer to that effect. But since substantial evidence was led by the plaintiff on that, he had to be cross-examined on that. Only 2 or 3 portions I will show your lordship. I will show your lordship 2 clauses from the insurance, 1 clause from the hypothecation agreement, and 1 from the master credit terms appended to the facility letter obtained by the plaintiff from the bank. To just show your lordship that if there is a loss to the goods which are my security, then I have the option either of appropriating the proceeds and reducing the facility, or of calling upon him to reinstate the security. Now, kindly, my lord, will take the judge's brief. Yeah, my lord.
Have you filed any notes of argument?
I will file, my lord. I'll
Whatever you
complete
will do, whatever will you do, you refer the documents with in terms of the exhibit number.
Yes, I will do it. In the notes,
Here I am just going through the judge's brief, but in your notes of argument, you mention it in terms of your exhibit number.
Yes, yes, I will give your lordship the exhibit number also.
Volume 2.
Volume 2. Page. My lord, kindly start at page 187. This is exhibit 7. This is the master credit terms.
$187, 10 rupees stamp paper.
Yes, yes. This is the master credit terms. Your lordship will find that at page 189.
189. Let us start from 189.
Yes. But the only relevant clause that I want to show you is clause 12.11, which is at page 197.
Clause
12.11 at page 197.
Your Lordship has found the clause insurance. If the bank requests, a borrower shall obtain insurance for any asset or property specified by the bank, obtain insurance against
If
loss of
bank request,
a borrower shall. Borrower here is the plaintiff, I am the bank. Obtain insurance for any asset or property specified by the bank. Obtain insurance against loss of life, total or permanent disability of the borrower and or such other persons as the bank shall require. In either case, through an insurance company approved by the bank on the bank's required terms, including without limitation, the insurance coverage amount, meaning the bank as loss payee, naming the bank as loss payee and endorsing non-cancellation and loss payee clauses. Assign or procure the assignment of the relevant insurance to and deposit or procure the deposit of the insurance documents with the bank and
Mr. Bosch, be slow. I am not so fast.
I am so sorry, my lord. Assign or procure the
Which
assignment.
paragraph you are referring to?
12.11a, Roman 3, I was reading. Assign or procure the assignment of the relevant insurance to and deposit or procure the deposit of the insurance documents with the bank. And this is most vital. In the event that the borrower becomes entitled to make any claims on such insurance, promptly do so and apply all monies received either in reinstatement of the relevant asset or towards the repayment of such facilities as the bank shall elect. So, my lord, on the face of it, unambiguously, the choice is that of the bank and not of the borrower. Now, so far as insurance is concerned, my lord, kindly see 12.11b, Roman 3 and 4. Arrange for insurance cover on the borrower's account if the bank does not receive the required insurance policy document by the date of activation of the facilities or renewal insurance policy document by the expiry date of the existing policies and receive commission from any insurer for referring insurance business relating to any assets, obligor or facilities. So I was within my rights to refer them to an insurance company, get them to obtain the insurance company and receive a commission. And if there was a claim under the insurance policy or if there was a receivable under the insurance policy, I had the right of electing how to apply the same. Now, my lord, apropos this, kindly also take
this you are referring to paragraph
12.11 A4 B4.
Receive commission from insurer.
Yes, as agent. So the borrower is put on notice that I will act as agent for an insurance company and I may receive commission from the insurance company for insuring the facility that I have granted to you, and the insurance will be obtained at your cost. Now, if your lordship now comes to the document at page 158 of the judge's brief. This is exhibit 3.
Hypothecation.
Yes, this is exhibit 3.
The previous one is exhibit
7. Now, the document at page 158 kindly comes straight away.
This is exhibit
3. Kindly come straight away to page 159. Clause 7. The borrower shall at the clause 7, your lordship has found it. The borrower shall at the borrower's own expense maintain and preserve the hypothecated assets, being stocks and machinery, in good and marketable condition and insure the same, noting therein the bank's interest, comprehensively including for loss or damage by fire, theft, lightning, riots, civil commotion, war, and for such further risk as the bank may require for the full market value with an insurer approved by the bank and shall
So goods are hypothecated to you. Were
Yes.
hypothecated to you.
Yes, those goods get destroyed in the fire. So my security is gone. Now I have a choice. Either I ask him to reinstate the security or I appropriate the proceeds from the insurance against the facilities and reduce the facility. The bank shall have the right but no obligation in the event of the borrower's failure to maintain, preserve and insure the hypothecated assets being stocks and machinery to maintain, preserve and insure at the borrower's cost and expense. So if he doesn't take out an insurance policy, I have the right to take out an insurance policy in his name at his cost.
Your right of adjustment, where is your right of adjustment?
Right of adjustment flows from the master credit terms, I just showed you. 12.11a.
This was executed between
the plaintiff and the defendant number 2.
Purpose is
for these are the terms on which, these are the master credit terms on the basis of which the facility is given to the
defendant.
Plaintiff by the defendant number 2.
Defendant number 2, and at the same time as a collateral security, this hypothecation was done.
Yes. Kindly see the facility letter that is at page 113, Exhibit 1. This is the facility letter, my lord. I need not show your lordship the entirety of it. Kindly come to page 119. Just to show that the hypothecated goods were my primary security. Kindly see security documents, primary security, hypothecation of stock and book debts. So the stock and the book debts are my primary security, not collateral. Collateral was immovable property and fixed deposits. Now, my lord, kindly also see for the purpose of our claim, my lord, this clause is the only one that is relevant in this suit. So I have shown your lordship the facility letter, which is Exhibit 1, starts at page 113. Stock and book debts, primary security. In addition, to create the security, there is a hypothecation. There is an obligation in the hypothecation that he will have to keep it insured. And in the master credit terms, which form the basis of the facility, there is an option given to me that if there is a money that becomes payable under the insurance policy, either
which para you refer to? Master credit?
Master credit terms, paragraph 12.11a. Page 197. 12.11a, subparagraph 4. In the event that the borrower becomes entitled to make any claims on such insurance, promptly do so and apply all monies received either in reinstatement of the relevant asset or towards the repayment of such facilities as the bank shall elect.
This money shall be applied
either for reinstatement of the asset or
either in the reinstatement of the relevant asset
or towards repayment of the facility
as the bank shall
elect. So it is solely my prerogative to elect how I treat
and
the
you
money.
did it.
And I did it. Now, my lord, there is every year a renewal of the facility letter. I will not place all of them. They are virtually the same documents. What I want to point out is that there is a
Question is whether we had a right to do that.
Yes, there is. I just wanted to show your lordship that there was
Another thing is that at the time of fire, whether these documents were existing or not.
Yes.
When fire broke out?
2015.
2015.
Yes. The 2012 agreement is there, followed by a renewal every year.
What is that?
Yes. Kindly see the renewals, my lord, are
prevalent on 2015.
Yes.
Where
I
is
will-
that document?
Page 26. Your lordship will have to look at the two documents which start at pages 256 and 260. They are the two relevant letters.
256
and 260. Exhibits 12 and 13.
Supplementary PCDT.
Exhibits 2 and 3. Sorry, exhibits 12 and 13.
Exhibit 12 is page 256.
Yes.
And 13 is?
Exhibit 13 is 260. There is no dispute that the facility continued to be subsisting.
There is no dispute.
Absolutely no dispute. And in fact, the master credit terms were also renewed in 2015 on 19th of August. That your lordship will find at page 362. That is exhibit 21. One plenty. Plenty. 362, and your lordship will find that the same clause 12.11 also appears in this document.
19/8/2015.
Yes, 19th August 2015, and the same clause appears at page 374.
Yes. This is exhibit
21. And I must correct myself. The fire was on 8th of June 2016. Now, to show that the facility was subsisting, August.
'15.
8th of June 2016. Now, kindly, therefore, also takes a note of exhibits 15 and exhibit 16. Exhibit 15 is page 273.
Supplemental facility letter.
Yes. We refer to the banking facility letter dated
No,
24th.
this was 30th September dated 15.
Yes.
39/15. So it should be
Yes.
previous. Fire broke out in June.
June 2016.
16.
And even after the fire, and this is the document that I'll show your lordship. After the fire,
this is exhibit.
This is exhibit 15, 1-5. And then your lordship will kindly have a look at exhibit 16.
Exhibit 16 in page
278.
This is subsequent to that.
Yes. Subsequent to the fire also, facility continued.
So your case is that you had a right to adjustment and you did it.
Yes. Now, when we confronted this to the witness, if your lordship kindly takes the cross-examination of the plaintiff's witness number 1, it should be part of the report of the commissioner. Commissioner reported খাম হবে। এগুলো তো এক্সিবিট। রিপোর্টটা খামে হবে, রিপোর্টটা তো আনসিল করতে হবে। The cross-examination method starts at question 201.
Saurabh Gupta.
Saurabh. Kindly come straight away to
question number
214.
214.
Kindly come to page 197 and look at clause 12.11 of the master credit terms. Do you find that the said clause provides in the event that the borrower becomes entitled to make any claim on such insurance, promptly the clause is quoted? Answer is yes, it is there. Then I suggest to you that the defendant number 1 was entitled to appropriate the proceeds of the claim lodged by you with the defendant number 1 towards repayment of its facilities. What do you say? I disagree. I was never asked by the banker defendant number 2 to repay any of the facility provided by them to us even after the fire incident had occurred. Moreover, they had even renewed our facility after the occurrence of the fire incident. Therefore, I disagree of making any repayment to the defendant number 2 from the proceeds of the claim lodged by me with the defendant number 1. Now, it's not his choice. He does not have the option. Then I am suggesting to you that it was the bank's sole prerogative to elect the manner of applying the proceeds of the claim lodged by you with the defendant number 1 under the master credit terms, and your opinion or consent was not required to be taken by the bank. What do you say? He disagrees. Then there is a voluntary statement. Since my claim against the defendant number 1 was much more than the facility provided by the defendant number 2, so I do not agree with the contention that the bank's sole prerogative to elect the manner of applying the proceeds of the claim lodged by me with the defendant number 1 under the master credit terms. Now, my lord, kindly come to question number 223.
Just a minute.
I'm sorry, man.
Just a minute. Let me go through it. So what would be your argument is that the fact is not denied.
No.
Something is written
Yes.
in black and white.
Black and white.
I can interpret it in one way, you can interpret different way.
But ultimately what is written will prevail.
And there is no dispute on the written terms.
Now, my lord, let us come to the case against me or liability, whether I can be foisted with any liability by virtue of my agency. Kindly, my lord, have a look at the Contract Act.
That is not available here. Unfortunately, Contract Act is not there.
My lord, I have looked at it. Kindly come straight away to section 230. Agent cannot personally enforce nor be bound by contracts on behalf of the principal. In the absence of any contract to that effect, an agent cannot personally enforce contracts entered into by him on behalf of his principal, nor is he personally bound by them. Presumption of contract to the contrary. Such a contract shall be presumed to exist in the following cases: where the contract is made by an agent for the sale or purchase of goods for a merchant resident abroad, where the agent does not disclose the name of his principal, where the principal, though disclosed, cannot be sued. Now, there is no presumption in our case because it is not that I am the agent of a person resident abroad. It is not that I have not disclosed the name of the principal. It is also not that the principal cannot be sued. If that is the case, my lord, then I am not personally bound by a contract of insurance entered into by the defendant number one, of whom I am an agent, with the plaintiff. The terms of the contract between the defendant number one and the plaintiff cannot be enforced against him. The absolutely clear. But I'll stop here today. I'm done. I will just cite 2 judgments on this. I'll come back with a note, place the judgments on the next occasion.
Heard in part, adjourned to 9 January. 9 January is okay?
My lord, can it be between 11th to 21st January? I'm being led by Mr. Kankani, especially requested. 11th to 21st.
20th January.
Gratefully.
20th January.
Okay, documents लेते हैं. Change.
दे दो.
Obliged.
20 तारीख. Non-commercial matter, item number 1, CS 42 of 2006, APG House Private Limited versus Coal India Limited.
Your Lordship, I'm appearing for the petitioner in this matter. Your Lordship, we were under the impression that the file GA8 had been misplaced, but we have just gotten to know from the report that it has been sent to the godown. So we would just like the file to...
File of GA number 8 of 2020. GA 1599 এটা কি আগের নাম্বার? Old number GA 481 of 2020. এখানে কোথায়? এখানে GA number 1599 লেখা। এও affidavits are there, affidavit in opposition, affidavit in reply.
Yes, yes.
কোথায় দেখো ওগুলো আছে কিনা? Affidavit in opposition.
Yes, Your Lordship.
Affidavit in opposition আছে, এও আছে দেখো। এটা ইয়ে কোথায়? পেজ কোথায়? ফার্স্ট পেজ কোথায়? ফার্স্ট পেজটা তো লাগবে। Landed register original site shall intimate this court on the returnable day whether affidavit in opposition in GA old GA number 1599 of 2012, that is GA 8 of 2020, was filed or not, and shall send the affidavit in opposition, if any, to this court. Let the matter appear in the list on 14 January.
Opposition was filed, Your Lordship. Leave can
Not
be granted to
traceable.
reconstruct, Your Lordship.
First, let me trace it out. When the other documents are available, other cost papers are available, why it should not be? Let the report comes. It will appear from the register itself, whether it was filed or not.
ওইটা নেই, খালি রিপোর্টের কপি আছে। না।
Item number 2,
My lord, this in
I
this
for the
matter,
respondent.
your lordship has passed a decree for possession on compromise. Now, the date of the reports of the official liquidator has, there's a typographical error. I've indicated the dates,
এগুলো কারেকশন করে দাও।
indicated the date. My lord,
This will be
has
corrected.
no objection.
Deeply obliged.
Deeply obliged.
It will be corrected. Don't be so excited.
I'm sorry.
item number 3,
You are here in
PLA.
Lordship, after your lordship's intervention, we have received the fixed deposits. But the question is whether the department is correct in directing us to deposit the fixed deposits by way of a lien.
No, order sheet.
No, it was only with regard to the release of the fixed deposits.
এখন কি করা হলো এই ফিক্সড ডিপোজিটে কিসের জন্য অ্যাপ্লাই করেছে?
Even the department is acting in a something that I do not know in what fashion, neither in the rules, neither in the law. They're asking to deposit a fixed deposit of the surety amount.
এটা দেখতে হবে। I will check it.
Lordship will kindly call for a record from the register of the insolvency that will serve the purpose.
Adjourn to report of the learned register original site dated 12/12/2024 be kept in record. Adjourn to 21st January. আপনি একটু আসবেন, এটা নিয়ে একটু বুঝে নিতে হবে। আমি বলে দেবো, আজকে যদি সময় পাই ভালো, তাহলে আমি পরে বলে নেবো।
Item number 4, Srimati Beena Devi Bagari and others versus Ruchi Bagari and others.
কি কারেকশন হবে? কে আছে?
আমি জানি না, আমি তো অ্যাডেড রেসপন্ডেন্ট।
কি কারেকশন হবে?
অ্যাডেড ডিফেন্ডেন্ট।
But today's matter is come for correction. I don't know why matter is come.
Correction, what corrections are to be made?
They have not done any mentioning.
এই এখানে একটা কপি তোকে দিলাম যে।
You are appearing in person.
না না
For the corporation, we have been added as a defendant.
What correction is to be made? Adjourn করে দিয়ে দাও, ছেড়ে দাও পরে। Let the other parties appear. Let me know.
Let it be after in the new year.
Yes.
As per the order, 29 April is the date.
29 January.
29 January. They have to file the affidavit.
Yes, I will also take care whether what corrections are to be made, because it came to the list after mentioning.
I don't see any mentioning for it.
Let it come on 29th.
Malad would kindly record an order that KMC has entered appearance.
Give a slip. Learned counsel for the KMC is present. adjourn to the Mr. Bagadia. Bagadia, huh?
Plaintiff number 1D, Ajay Kumar Bagadia.
Mr. Ajay Kumar Bagadia, the plaintiff number 1D is present in person. None appears for the other parties. Adjourn to 29 January.
I will serve the copy affidavit.
Yes.
Order copy. That's passed.
File it. Previously, prior to filing the application, serve it. Affidavit, you serve it.
Item number 5, PLA 143 of 2009 in the goods of Beni Madhav Banerjee.
My lord, I am for the petitioner herein, my lord. This is an application for revocation. My lord, my affidavit in reply, my lord, I need 7 days time to file the affidavit in reply.
An accommodation is sought for by Mr. Das.
Time was given twice out. No, my lord.
To
My lord,
file
only on the
affidavit.
last occasion, the affidavit in opposition has
When-
been filed.
When probate was granted?
My lord, it was granted in 2009, my lord. 10.
1st January, then again once.
When have you filed this application for revocation?
In 2023, my lord. My lord, I have come to know after a plain in a written statement, they have disclosed the particular grant of probate. In 2023, I came to know. I have filed immediately. My lord, this matter, my lord will produce the orders. Only on the last occasion, the affidavit in opposition has been filed. Prior to that, it was not filed for over 1.5 years. My lord had closed their right as well. Thereafter, my lord allowed them to file the affidavit. My lord, the particular the deponent is not in Calcutta, which is why I could not have it affirmed. My lord, I will have it affirmed. My lord, may keep it then.
কি বললাম? An accommodation is sought for by Mr. Dash for filing affidavit in reply. Full stop. The same shall be filed on or before the returnable date. Let the matter appear in the list for hearing on 16th January.
My lord, will kindly grant any other date because my
Yes.
junior is getting married on that date. Any date.
14th January.
Very well, my lord. I shall be much obliged.
Take care of limitation.
My lord. Well, my knowledge is later, which is my pleading, my lord. Much obliged.
Whether limitation will save you or not, you have to argue on that.
Yes, sir.
That is the very basic point you have to argue.
317 has been complied with. Inventory accounts.
Item number 6 in the goods of Radha Nath Shil.
This is my application in a probate application. Now I'll just briefly indicate the facts of the case. Today I am praying for a very innocuous order. My lord,
Mr. Sinha, who are you?
I am the
I may I just indicate the fact there are two wills of the testator. The first prior will was in the favor, and there correspondingly there are two probate applications. The prior will was in his favor of his nephew, and the second last will was in favor of Ramakrishna Mission. Now two probate applications were taken. The second probate application. Second, my lord, probate application was taken by the executor, Mr. R.L. Addi. In the second probate application, my lord, the executor has renounced his executorship. That's why there's an order for conversion of the application application for letters of administration. That order is there. I've annexed that order. Now,
which page?
That order is at page 51. Page 45. 45. I'm sorry, 45.
Your lordship will come to page 47.
47. So I'm at 48.
This is my one. 48 is mine.
It's 47. IGA number 8 is the conversion. Kindly come kindly come to 47 IA number GA4 of 2023. The applicant Swami Purnananda, Secretary Ramakrishna Mission, has filed the present application with praying for conversion from grant of probate to letters of it because the executor has renounced. So for amendment of PLA application, which is annexed. The caveat has filed an affidavit to the said application and submitted that the alleged will, on the basis of which the present application intends to convert the PLA application for grant of probate to grant of letters of administration. The said alleged will has not been executed by the testator and the said will is a forged document, etc. The court finds that with regard to the genuinity of the document, the same cannot be decided in the present application, as the executor appointed by the has renounced from the executorship said will, and the petitioner being beneficiary of the said will intends to continue with the case. Accordingly, prayer agency is allowed.
Who is the caveator?
My learned friend,
Your
the
caveat.
nephew. He has taken out probate of a prior will. They both are pending. Now after that, when we went to the department said that the Secretary Ramakrishna Mission's name should be inserted further amendment in the cause title in the first page of the application. So we made a prayer before this honorable court, and this was again allowed. That is at page 51. Kindly come to the order at page 51.
Yes, he is seeking for letter of administration.
Yes,
that's why his name should appear.
His name appear. Now, if you kindly look at the order at page 51, it says.
Yes, I've seen that.
Cause title. Actually, it should not be cause title. It should be kindly come to page 132. Your lordship will get page 132. This
132.
Yeah, now 132 is my application, which amended application, the amendment with proposed amendments. Now kindly see, it is not in the, have your lordship got that 132? It should not be in the cause title, it should be in the body, the humble petition of Swami Supurnananda. That's why the department is saying this should be corrected. I had mentioned the matter, the learned judge said when I sit, Justice Sinara was not sitting. So he said, I'll do it when I say. The minor, it should not be, it should be in the first page, not the cause title. It is really just below the cause title. This should come. The correction should be incorporated in the portion below the cause title, not in the cause title. That's my.
Where is the corrected cause title? Have you filed this?
Oh, no. It was the correction was done after this is the amended application. If further this should be inserted. That order is there. Wrongly, it is by it is mentioned cause title. It should be this portion below the cause title. That's why department is saying that you have to get a clarification so that they can do it.
So you can do one thing.
Yes.
Humble petition of.
Yes.
Now you put the name.
Swami Supran. That's what that order is there. That order is.
But this corrected copy doesn't contain it.
No. That order to put in the name is there, but it says in the order at page 51, it says cause title. It should not be cause title.
Two issues are there.
Yes.
First, it would not be cause title.
Yes.
Second thing,
yes.
This name should be inserted in your amended plaint.
Yes,
corrected plaint.
Yes, that order is kindly see 51 that name. Yes,
corrected order is there, but what have you filed is without that name.
Yes, that's why that I.
So I can pass direction to file you a fresh corrected copy of plaint, proposed amendment containing proposed amendment.
That order when I prayed for Justice Sinara, kindly come to page 51 for a moment. Just 51 for a moment. Just
132 was shown at the time. The page one, what is appearing at 132, that was shown to the learned judge, and thereafter he passed the order in page 51. I think the chronology is getting mixed up. What had happened is the original order at page 45 was passed. Thereafter, this page 132 was presented.
When this was shown, when
thereafter,
my lordship Justice Sinha passed that order at page 51.
Even the proposed amendment is not in terms of this order.
No. This amendment originally this was there.
Listen patiently. This order is for amend cause title, whether right or wrong. Yes. Amend cause title in the first page as Swami Supurnananda. Yes. You have not put any corrected proposed corrections. You have not made this name.
No, I mean, I have not been able to make myself clear what happened. I had filed this application only without his name of Swami Supurnanand. But when I pointed out that all the amendments have been allowed by Justice Krishna Rao, but the department is saying you have to put in his name, otherwise that should be required. So when I mentioned with this, the Lordship said, very well, do it. You get that order. You don't. He did not. His Lordship did not insist that a fresh application should be mentioned. He said just put in the name. It was just a question of name. That's why his Lordship was pleased to pass that order at page 51. That's what I understood. So if your Lordship now is more desirous of, I should file a fresh application.
That cannot be done. This is not the way of doing things.
But your
Very
Lordship,
well,
may I just indicate one thing. If you see 132, the originally how it has been framed is really the correct way. What they have filed is actually the correct way. The name of the
normally it is not
cannot be there.
Because once again it is to be changed.
So not only that, your Lordship. Yes, it can be changed because a person may lose his position, may change. That can be changed. One, because it has been given to an institution.
Yes, not by name.
Not by name. So that this department, what they're asking for is itself wrong.
Secretary, Ramakrishna Mission.
Your Lordship, even that is not that. Supposing a company is being represented or an organization.
It need not be.
Organization is represented, the organization's name.
Yes.
Say whoever in the organization will be.
No, for any clarification, let there be secretary.
No, I think why the department is saying, because in the probate application, we said it was affirmed by Swami Swarupanand. That's why
how your Lordship doesn't.
Whoever would be the secretary, we will do that.
Yes, your Lordship, I think that should be the order. First, let them get this number thing done, then the rest of the application, we can proceed thereafter.
This hurdle has to be crossed, then I proceed with the other prayers in the application.
Yes, sir. Get them proceed.
Kindly, my lord.
Liberty is given to the learned counsel for the petitioner to file corrected copy of petition, probate application containing proposed amendment wherein the word secretary shall be inserted in the first page of the application.
Your Lordship, may I just suggest, otherwise again the confusion will reign. Secretary, your Lordship just indicates before Ramakrishna Mission. Before Ramakrishna
shall precede
yes.
the word Ramakrishna Mission in the first page of the probate application. Once that is filed, the amendment application shall be heard.
My lord, may I file it by way of a supplementary affidavit?
Just I am going to dictate this. This proposed amendment may be filed along with a supplementary affidavit, which shall be kept in record and which shall be served a priori to the adversaries.
And this application let it remain pending. I have got other prayers. One, this is allowed, then I can.
Let this be done first.
Yes. So I'll file it with a
appointment of receiver and all these things are there. That will be taken care of later on.
I'll file it with a supplementary affidavit.
Yes. The matter will appear in the list. How long would you take?
After the vacation. After 9th, my lord, any day. 8th, 9th, there's some my matters fixed up.
16 January. 16 January. Swami Supurnananda possibly is more commonly known as Shottoda.
Yes.
Item number 7 in the goods of Piyush Kumar Roy Chaudhuri.
This is my application. This is an innocuous prayer, my lord. One of the legal heirs have filed a caveat. This is my application for converting the PLA application to a testamentary suit.
Caveat was discharged. Who is the caveator?
My lord, on the last occasion, Shormi Dotto.
A caveat should be heard first. Was there any order on caveat?
Yes, my lord. He has filed an caveat. Thereafter, an
What are the
application,
other orders?
application was filed for filing.
First, we have to hear whether the caveat is to be heard or caveat is to be allowed or discharged.
But she has also filed an affidavit in support of caveat.
Might be that is to be heard then. Order sheet গুলো দাও না. Whether she has or he has any caveatable interest or not, that is to be the first point to be decided.
Probably she has. He is representing one.
Affidavit was allowed in support of caveat. That is in 23, October 23.
Yes, ma'am.
None appears for the caveatrix, although learned counsel for the plaintiff, Mr. Sengupta, is present. An application GA number 2 of 2024 shall be taken up after hearing of the caveat. Let the matter appear in the list on 28th January for hearing of caveat. A copy of this order may be sent to the caveator or caveatrix?
Caveatrix.
Caveatrix by the learned counsel. And the affidavit of service shall be filed on the returnable date.
Grateful, my lord.
My lord, I beg apology for item of 4, my lord. Just by the side of this court is going on, my lord, hearing.
That has
My lord, there is
heard.
only one, yes, my lord, there is only one line cut, just one A it will be, my lord. I
On the
appeared.
next date. Next matter.
Item number 8, in the goods of Nandorani Devi Nandorani Bhattacharya Bhattacharji.
My lord, I am for the petitioner. My lord, I have effected service of your lordship's last order. My lord, may I file my affidavit of service?
Special citation. General citation.
My lord, all that has been completed. My lord, by your lordship's order, my lord, your lordship had directed that the disclosure inspection should be carried out and framing of issues. My lord, I have a copy of suggested issues. My lord, I have also
This is
effected.
TS.
Yes, my lord.
Who is the other side?
Well, they are not appearing, my lord. My lord, I have, my lord, since your lordship had indicated by your lordship's order dated 3rd December that a copy of the order may be communicated. My lord, I have done so. My lord,
None appears for the defendant. In terms of order dated 3rd December 2024, direction was given to complete disclosure of documents, discovery and inspection. Giving one more opportunity.
yes, my lord, that I leave it to your lordship. But my lord, I must indicate one thing. My lord, the affidavit of documents I have filed it already. My lord, that has been recorded in the order of.
Come on the next date.
Very well. Very well, my lord. Well, I have my suggested issues if your lordship.
Come on the next date. Let one opportunity be given.
Yes, my lord.
Let this suit appear in the list. On 28th January. No, let it appear on 4th February.
Will it be your lordship's pleasure to record that I have filed the affidavit of service today?
Yes, affidavit of service filed by Ms. Mukherjee be kept in record.
I'm so grateful.
Item number 9, in the goods of Vishwadev Banerjee alias Vishwadev
My lord, in
Bandyopadhyay.
this testamentary suit, I am for the plaintiff.
Who is the other
The
side?
other side.
My lord, I beg
Defendant
to
is not
appear
appearing, my lord.
Lord, I
Defendant
beg
is
to
not
appear for
appearing, is
the-
the intervener. He filed an application, GA5, my lord. The pleading has been completed.
GA5, what is in GA5?
Lord,
He's claiming is the
GA5
wife of the testator.
GA5 is my application filed by wife of the testator to intervene to grant your lordship's leave to intervene in the proceeding. I tell your lordship the brief background of the case. But this is my affidavit of. An application for probate was filed by.
What are the grounds?
Well, grounds I am the legally married wife, and this fact is known to the executrix, who filed because when after the death, the testator was an government employee. He was working as a medical officer and retired as a vice president of a renowned medical college. After his death, the executrix before your lordships raised certain objections. We also made certain application that being the legally married wife, we are entitled to the benefits. And as because she was, the testatrix was appointed as one of the nominee in the service records, she got some benefits. But being a wife, I got, and this fact is known to them. And there were also in my application I have stated, there were we were not aware of the applicant before your lordship being the wife is not aware of any will. What's my lord, a will has been, my lord, an application for probate has been filed without citing any notice, stating that he is not married. But sir, lordship, I will in my affidavit of reply, I have stated some documents wherein it is absolutely clear that the executrix knew that I am the legally married wife. My lord, your lordship, first take my application. My application, I have annexed the marriage certificates. My lord, the deceased.
Where is AO?
AO is my lord filed. I have used. Lordship kindly sees page 13 and 14 is the, my lord, certificate of marriage, and this marriage.
What are your objections?
Yes, yes, I filed.
What are your objections?
Well, she is a false person. She is not the wife of the legally married wife of the testator. She is an alter ego of the defendant. Well, in one hand, the defendant claiming herself is the legal heirs of his brother. Now, other hand, the defendant showing the marriage certificate of the lady. Other hand, she is saying, you know, my brother was married, but the will says nothing. Millet. I have narrated everything, Millet, how the faults have been happened here.
May
The probate has been filed in 2015, Millet. 2017, additional affidavit in support of caveat has been filed, wherein the defendant first time saying her brother was married and showing some false certified copy of some marriage certificate. Milord. Totally false, Milord. I'll prove, Milord. Let them complete my argument, my brother. Then I'll answer the next step, Milord. I'll kindly take the will once, Milord, at my affidavit in opposition, page 61. Is a doctor clearly stated. And I have narrated how the false statement has been made in my affidavit of opposition. I'll satisfy my.
So your point is, let me hear him. Yes. Yes, I got the point. The rival submissions, rival points, arguments.
My lord.
Now you said you are the wife.
Yes, my lord.
In support of that,
My
what
lord, I have annexed, my lord, at page 13 is the marriage certificates.
Right.
At page 13 and page 14 are the marriage certificates. Page 15 is the death certificate, which was lying with me. And page 16, your lordship sees, this has been issued by the Office of the Principal Accountant General, Treasury Building, Kolkata, intimating with regard to issuance of pension payments orders. Your lordship sees, it has been issued in the name of Chanda Banerjee Ni Chatterjee, wife of late Bishop Dev Bandopadhyay, medical officer. My lord, the before I make further submission, may just background of this particular case. That an application for probate was filed by the testatrix. At that application, it was only stated that the testator died as a bachelor, leaving behind two sisters. One of the sister is the executrix herein, is Junu Banerjee, and another is Ranu Banerjee. And one of the sister was there, he died long ago. This Runu Banerjee, he, upon receiving the notice, she came forward, filed an objection, filed a caveat, and in support of caveat also filed an affidavit.
Correct, sir. Not Runu Banerjee, Reena Bhumi.
I stand corrected. And there was a contest. At the first instance, Reena Banerjee also did not disclose that he's married. The testator was married. We were not aware of this. In the meantime, probably Reena Banerjee.
Whatever that might be. Issue is,
yes,
the relationship is
yes,
highly disputed.
Yes, yes.
he has prima facie filed marriage certificate and other documents.
Yes.
Now, if I say no, these are false documents.
Yes, this is a false document. Prima facie
Right.
I'll prove, my lord.
If it is so,
Yes.
if I decide this, I am adjudicating upon these documents. That I cannot do right now.
My lord.
So I am not
Lord,
giving
other aspect to be, my lord, decided, my lord. My lord, let me hear out. Let him complete, then I'll argue completely, my lord.
main issue.
Yes.
You should argue what points you should highlight is that if this court right now says that these documents are false on the strength of your submission, that means that is tantamount to saying that deciding on these documents. This court, this testamentary court cannot decide on that is a declaratory decree like that.
But a prima facie case is this, my lord. What
He will do,
Yes.
what she will do, she will only appear in the matter, contest the probate. This court will only see whether probate of the will can be granted, whether it was executed in any suspicious circumstance, and like this.
Yes, my lord. But prima facie, he has to satisfy.
Her right cannot be decided. She is just caveatrix.
No, not caveatrix. The will says the testator is bachelor. He's a doctor. But I'll
manufactured.
First,
both,
let him,
both rival claims are there. Probate court cannot decide.
The situation is this, my lord, that the original Rina Bhumik, the defendant, sisters of the testator, we filed an application in 2015. We said the citation has been issued upon the Rina Bhumik. Rina Bhumik filed the caveat. Affidavit in support of caveat has been filed. In 2017, additional affidavit support of caveat has been filed. In 2017, Rina Bhumik herself disclosed on the Xerox certified copy of a marriage certificate. Thereafter, the matter posted into contentious cause, and testamentary suit number has been given. Judge's brief document ready. It was on the date matter was fixed for the hearing of the suit. In the meantime, in 2024, from 17 to 2024, this application is come before your lordship, below. So there is a link. Suspicious circumstances, I'll privacy prove.
That's why her presence is needed, because if it is proved that
is first, this matter has to be disposed
I am
of.
not decided. Right, absolutely.
Yes, this
But
GA5 has to be
at the
disposed
time of allowing this Order 1 Rule 10 application or an intervention application, I cannot then venture to decide on so many issues, whether these marriage certificates are wrong, bad, on all these things.
But there is a limitation question is there, my lord. She knows, she was watching the proceeding, what is happening in the court, my lord.
Question of fact. Probate is yet to be granted. All right, you want to come further, make further arguments,
Yes,
come on the next date.
Let it,
But
my
this
lord,
is my view and address these issues.
Yes, my lord.
And also, my
Let
lord,
Heard in part adjourn to 14 January.
My lord, any time, my lord, please? Any time, my lord? 12:30?
No.
grateful lodge.
My lord,
Follow the
another
list.
application is there, my lord. Another probate application is there, my lord.
When that is fixed?
No, this is there, not GO. PLA number 543 of
Item number?
2022. Same item number, my lord. 543 of 2022. My lord, let
In the meantime,
my lord, the citation
Part
issued upon
GA5 of 2024 in part adjourn to ওই কবে বললাম ডেটটা
14
For-
January.
for further hearing. Full stop. Both the probate applications shall appear together.
My lord, here the citation not yet been issued, my lord.
In which one?
Is for 543 of 2022. My lord, let citation be issued in
Citations be issued
in terms of
in
the prayer,
PLA 543 of 2022 in terms of order dated.
in terms of prayer, my lord. What is the PLA?
That proceeding, my lord, prepare.
Listen. In terms of prayer, my lord, C.
Priya state কোথায় গো?
B, in terms of prayer, B, my lord.
No. Citations may be issued.
Yes, in terms of prayer, B and C of the probate.
B and C are not for citations.
Yes, my lord. B is the special citation be issued upon the petitioner, upon the
PLA
person mentioned in 3A.
No. These are not here.
PLA then. Not GA. PLA what I need. But the
Citations may be issued in PLA ওই যে নাম্বারটা বললাম ওই নাম্বারটা দিয়ে দাও.
543 of 2022.
Yes, that is enough.
Item number 10, PLA 177 of 2018 in the goods of Mrudula Shangvi. This is
This is an application for grant of probate, my lord. filed by the two names executor in the will. My lord, everything has been completed. My lord, initially citation was asked for and citation was issued. And my lord, citation was complete in respect of one and two others were, my lord, incomplete.
Any paper publication?
Yeah, paper publication was not required, my lord, because after the file and publication, issuance of citation, we came across, my lord, to know the other legal heirs there. One of the legal heirs died. Accordingly, my lord, amendment
Paper
was,
publication.
my lord, may I come? May I say, my lord? Accordingly, my lord, amendment was carried out, bringing all the legal heirs, and all legal heirs have been consented. All the those are in
It
file.
is submitted by the learned counsel for the petitioner that all the citations were issued.
Non-contentious issues.
A report is called for from the registry. This apart, paper publication intimating the proceeding shall be published. Most of the paper shall be one being the Bengali daily, the other being the English daily.
My lord, it is Gujarati, my lord.
Gujarati.
My lord, yes, my lord, there is a property in
Where the properties?
where property in Kolkata and also Gujarat. So my lord,
One English daily or Hindi daily?
Gujarati Delhi. I have
No.
the name.
In Kolkata, not Gujarati Delhi.
In
Only
Kolkata,
it will be in English Delhi.
English Delhi. My lord,
One English daily well
Time for
circulated in Kolkata, and the another Gujarati daily well circulated in the state of Gujarat.
my lord, kindly take the name, my lord. Otherwise, my lord, difficult.
A draft notice shall be approved by the learned register, by the registry.
My lord, they will serve. They will serve us the copy of the. My lord, it was, my lord, non-contentious, my lord. All
Let
the years,
there be publication.
my lord, Gujarati paper is Gujarat.
I will
Samaj.
not name you, publish it. I won't name it.
My lord, department will ask for the name, my lord. If my lord records in.
If the department asks for name, you ask them, they will appear, they will answer me.
Yes, my lord.
Let the matter appear in the list on 6th February.
Once in English, Calcutta, and
another in Gujarati in Gujarat.
In Gujarat, yes. Gujarati paper, but the publication will be in English language because we have no
Yes.
translator in
Yes,
Gujarati
yes.
translator in our department. Matter will appear, my lord.
6th February.
In the meantime,
With liberty to mention. If you are able to finish this, come and mention it. Or some more days.
maybe because, my lord.
More days.
Let it come, my lord. We will try to, my lord. It would be, my lord, in the meantime, my lord, if I publish in Gujarati paper in Gujarat, 283 of the Indian Succession Act will be complied with. That will be also there.
Item number 11, in the goods of Srimati Vimla Gupta, deceased.
My lord, item 11, my lord, the commissioner was supposed to file his report. My lord, we'll see my lord's last order. Commissioner, I'm told, my lord.
My lord, I beg to appear as the advocate commissioner in the incident matter, my lord.
I'm seeking to file the commissioner's report.
Evidence.
Yes, my lord. My lord.
Evidence of the two attesting witnesses is complete. Cross-examination by the defendant is also complete. My lord, caveated, rather, my lord. My lord, will kindly fix it for arguments. May the report be circulated.
How many witnesses were examined?
Two attesting witnesses. My lord. Two attesting witnesses and the executor, of course. 3 witnesses total.
3 witnesses.
Have you got your remuneration? কি করছে কি? Can't you see it properly?
Pardon, my lord.
Rohan Chatterjee, Advocate Commissioner. Anil Kumar Kejriwal.
Yes, my lord, that's one of the attesting witnesses.
PW1.
Yes. My lord, PW1, that's the attesting witness. My lord, there's no
Executor?
PW numbers. The executive number is Mr. Sunil Agarwal. He's also been examined, my lord. There are 3 separate sheets, my lord. Examination chief was done on one day and thereafter cross-examination on a separate date of the 3
Report of
witnesses.
the Advocate Commissioner is filed in sealed cover. Let the same be kept in record after reopening.
Copies can be
Learned
circulated.
Advocate Commissioner submitted that all
Yes,
his
my lord.
dues are paid properly. Fix 7 January for argument.
Obliged.
I'm serving a copy here.
My lord, copy be served, my lord. Copy he is serving here and now of the report, my lord. We don't have
Copies of the report may be served on the councils, learned councils.
and my lord, the commissioner may be discharged also, my lord.
The learned commissioner is hereby discharged.
Obliged.
Grateful, my lord.
Item number 12, in the goods of Dilip Kumar Mitra, deceased.
In this matter, my lord, I am appearing on behalf of the executives. But if this is a non-contentious probate application, my lord, service has been done. Paper publication has been done. And my lord, your lordship.
A report is called for from the department.
My lord,
Where is paper publication? Have you filed affidavit of service? Affidavit of compliance?
last month, your lordship kindly see the last order passed by his lordship, the Honorable Justice Divas Patnaik. Last order. The order happened, my lord.
Examination is also complete.
My lord, what has happened, my lord? The testator, my lord, made an unregistered will on 23rd August 2015, my lord. Thereafter, testator died in favor of executives. The testator was a bachelor. And
Now the question is, if the test, who was examined?
My lord, one of the witness was examined, and also an officer of Higher State Police Station was examined to prove the GD.
Executor was examined?
Yes, no. My lord, kindly, what has happened, my lord? The probate application was filed in the month of January 2020. Thereafter, my lord, the COVID restriction has been imposed. In the month of June 2021, my lord, the department informed the advocate record that the ordinal will is not with the application. Ordinal will is not with the application. The original will was the unregistered will. My lord, the copy was lying with the learned advocate on record. Subsequently, my lord, the will was not.
So letter of administration would be issued along with the copy of will.
My lord. Thereafter, my lord.
Was there any order to that respect?
Yes, my lord. No order.
All right, at the time of final order, that can be done.
My lord.
Because no special procedure is needed. All the witnesses are examined.
One of the attesting witnesses was examined because the Xerox copy.
Oh, do you need any witness examination further?
No.
Executor?
Well, the executor is the copy. Original will was not tested out from the learned advocate.
The executor is not examined.
Not examined.
Why?
Because, my lord, the original will.
Maybe executor will not prove the will.
My lord, one of the attesting witnesses has proved the will.
Absolutely. Executor will not prove the will. But executor will say why he is absent. He is the party himself. He must examine. The death certificate, he is supposed to produce the death certificate.
Like he has handed over the attesting witness.
The court needs him to examine.
My lord, she is staying at my lord in USA, my lord.
Then let him come at least.
My lord,
or over video conference that can be done. It can be done by video conference. I have in other matters, witnesses are examined by video conference. That can be done.
My lord,
without examination of the executor, how this can be? He is the party, she is the party himself.
My lord,
she is the applicant himself.
My lord, she.
It appears from the record that executrix.
My lord, consider, my lord.
Is yet to be examined. Executive should be examined. Fix 6 February for examination of the executrix.
Item number 13, in the goods of Sri Mihir Lal Banerjee, deceased.
But I'm applying for the my application, my lord, but I'm only paying for issuing a citation to the legal is. Issuing a citation to the legal is the only legal is. Prayer A and prayer B. The only thing I indicate, my lord, the legal is
A and B are allowed.
my lord, I
GA
must
90 PLA 92 of 2020 is filed for grant of probate of the last will and testament of the deceased Mihilal Banerjee. Full stop. Copy of death certificate.
annexed.
How it is Exhibit A. Witness examination is over.
Yes, madam.
Hmm?
Yes.
Then why citation?
My lord, the both of the witness was expired, died. So the daughter-in-law have proved it in solemn form, as per the direction of the honorable court. That's also done.
Prayer A and B. To whom you shall issue it?
My lord, Ashalota, the daughter of the testator. My lord, I am one of the son. I'm the executor. At the time
Are
of the
allowed.
death,
Prayer A and B of the probate application are allowed. General and special citation may be issued as prayed for. Let the matter appear in the list on 11 February.
date.
Yes, sir.
You are supposed to find the notes of the.
Lordship, I am led by Mr. Meghnad Datta. Lordship, he is on his way. Kindly allow me for 10 minutes possible. We will complete it by today.
For the plaintiff, my lord, I appealed for the defense by 11 that your lordship.
Lordship recalls Mr. Abhijit Mitra was submitting. He has completed his argument. Mr. Ghosh was to give reply.
The only thing I want to point out before your lordship, the material instruction has not been received for a long time. My lord, I will also ask for the instruction to prepare your and your lordship directed. The manager also taking steps, my lord. So my only thing I wanted to have it recorded that Mr. Mitra stated that because of this situation, in the next step, whatever your lordship did, I'll take to return action unless I get it. So that should be recorded.
You are supposed to give reply.
Yes, my lord.
Notes of argument.
We have filed, my lord, on the basis of that Mr. Mitra had argued, my lord. Lordship.
In my notes, I'll give when I finish submission. I'll give my notes. I
Would
can
you start today?
I had thought that my learned friends will their learned senior is in difficulty today, but they are all very eager to do it. But I am also his junior, so I think we should not do it today. I can start, but your lordship knows the facts. But the note your lordship had wanted, that note we have to complete also.
Come on the next year.
Yes.
Hard in part adjourned to
At least 1 week after the vacation.
17 January.
I don't know. We can ask to record also. Mr. Mitra states that he'll take to leave to retire in the next day, my lord.
That should not be. That we have because I have heard you partly. I cannot say will retire. I have to consider that.
You will also consider my submissions to my lord.
I have noted in an earlier order that you have made submissions. So I have to consider that. Where is Mr. Dotto?
Well, I'm appearing on behalf of the
Lordship, this is the probate matter which was listed.
matter, my lord. The other one.
Lordship, will recall we had sought for an adjournment since the witness is not in town. If your lordship may kindly adjourn this as
The other
well.
matter yesterday, my lord, that's sought for adjournment. My
Lordship,
lord,
since the witness is
When
not
will it
here.
come? How
Lordship,
long would you take?
Your lordship, we are almost UPL and the evidence-
UPL, your witness was in the box.
Your lordship, my witness, chief. Your lordship, going on, maybe next day we'll. Your lordship, Mr. Ghosh is. Lordship, maybe a day or two maximum.
That is not the issue. Issue is when he will come back.
The other matter is
any
appearing
day-
on 16th of January. No, post 16th, my lord. Anything.
Any day apart from 16th, either before or after.
On prayer of the learned counsel for the
Your lordship, caveator.
caveator, the suit is adjourned to. Why caveator? You must be defendant.
Yes, your lordship,
Because this is
defendant caveator.
contentious cause now.
Yes, your lordship, defendant caveator.
Defendant. The suit is adjourned to 27 January.
Grateful, my lord.
Hopefully you will be here after 26. After 26.
He'll be at his estate at Bolpur. He'll be at his estate at Bolpur.
26. Mr. Ghosh. Not 27. $29.
No, January.
Your witness action.
Yes.
Is there?
My lord, he is here, my lord. My lord, only one, my lord, submission. My lord, we have taken, my lord, a issue with regard to, my lord, whether, my lord, the present advocates, my lord, are authorized by the defendant or not. My lord, kindly keep that issue open, and without that.
Yes, I told you.
Yes, yes. My lord, kindly record
It will
that so
be
that-
expunged.
Yes.
And I have given liberty.
Absolutely. I'm so grateful, my lord. My lord, and my lord, absolutely correct. Let him, my lord, be, and let that get over, my lord. Perhaps, my lord, it will be better.
Pending for long.
Yes. My lord, kindly with that, my lord, we can, my lord, cross-examination, my lord, can start. With that, my lord, just that rider. Order in bola, no? My lord, that last order, my lord, perhaps, my lord, that is not, my lord, reflected.
No, two issues were raised.
Yes, my lord.
One issue is authorization.
Yes.
Second issue is existence.
Correct. Correct.
So first issue, existence, is the first thing to be decided. Because if this company is not in existence, then of course the power of attorney will cease to have exist.
And even if the company is in existence, then also my learned friend may not be
First thing should be decided first.
Very good.
Then the second will.
Correct. Correct.
Because if there is no company, then there is no authority.
Absolutely. Absolutely.
So let that thing.
Just without prejudice to that, my learned friend can start.
I have one submission. My learned friend should make it clear by authority what he means. That me.
He has filed no pleading, so you need not be excited. Please sit. He may say a lot of things. Nothing is filed. So please sit peacefully.
No, I could be then produce the necessary documents to show the authority.
That will be argued when that's what.
Why would you produce? He filed nothing to challenge that.
No, we have taken that point, Mullah.
When he will file, then he will produce. Please bring the witness.
Yes.
Yes.
Witness is here. We have not filed any application, but Mullah, it is there, Mullah, with regard to Mullah that.
He is PW1.
Yes, he was examination chief was done. Now Mullah the cross.
My lord, may Mr. Chaudhary. Mr. Chaudhary. Mr. Chaudhary, presently you are an employee of the plaintiff, Sonex TV.
নট এমপ্লয়ি, আমি হচ্ছে একজন কনসালটেন্ট।
Since when you are?
I am not an employee but a consultant of Sonex TV.
Since how long you are consultant?
প্রায় 12 about 16 বছর, about 16 বছর।
About. What is your area of work? What is your duties?
আমার মেন কাজ ছিল ইম্পোর্ট করা goods from the abroad, China, Hong Kong,
namely
etc.
Do you have any appointment letter about your?
এটা অলরেডি প্রডিউস করা আছে আমার।
have already produced the same notice honorary.
What is your education?
BSc.
Which year you have passed? Which year you have passed?
1972.
Which university?
I passed in the year 1972.
1972.
Which university?
Calcutta University.
Which college?
Narasingho College. Narasingho Datta College.
No.
Datta College.
Your schooling was in English medium, Bengali medium?
Bengali medium.
Which school you studied?
Which school you studied?
Oh,
আমি পড়েছিলাম সালকিয়া স্কুল
I studied Calcutta.
স্কুল, দেন বাদুড়িয়া ডিকেএম ইনস্টিটিউশন,
After that, Paduria.
ডিকেএম ইনস্টিটিউশন।
That's right. AA Institute. আপনি ফুল টাইম কনসালটেন্ট না পার্ট টাইম কনসালটেন্ট?
এই কোম্পানি, যে কোম্পানি সোনেক্স কোম্পানি, এই কোম্পানিতে আমি ফুল টাইমই কাজ করতাম।
Sonex private Sonex
সোনেক্স ইলেকট্রনিক্স প্রাইভেট লিমিটেড।
private limited Sonex, which is for
In the plaintiff company.
the plaintiff company as a permanent employee.
Not employee, I'm the
Permanent-
consultant.
Permanent consultant.
from which year to which year? Full time
Consultant.
ফুল টাইম তো আমি বলিনি কখনো, আমি বলেছি আই এম এ কনসালটেন্ট অফ দ্য
Consultant.
full time consultant.
না,
To attend the office
ইয়েস ইয়েস,
full time.
ফুল টাইম না, আমি আমার যেটুকখানি জব সেটুকখানি কমপ্লিট করতাম। আমার ইম্পোর্টের কাজ ছিল, অনলি ইম্পোর্টটা দেখতাম,
Job which was asked to me.
অনলি।
Please, please.
Which was asked to me, and my duty was to import the goods. আস্তে আস্তে বলুন স্যার।
Handled so far.
কতগুলো ইম্পোর্ট আপনি handle করেছেন এখন?
অনেকগুলো নাম্বারও বলতে পারবো না, এখন মনেও নেই।
Say the exact number.
মনে নেই, তার কারণ হচ্ছে এত বছর হয়ে গেছে, মনে রাখা সম্ভব নয় যে কতগুলো।
Long time back matter, so
হ্যাঁ।
I cannot recollect
হুম।
the exact number right now.
Remember about this report?
এবার আপনার মনে আছে?
100% আছে।
Yes. 100%. You remember from this? Correct.
Take a note. That
Sir, use the microphone. Sir, microphone.
মাইকটা দেখো।
Oh,
Sir, কোশ্চেনটা রিপিট করুন।
you have taken the oath before giving evidence from the witness box that you will speak the truth, only truth,
100%,
nothing but truth. Are you aware of that?
100% ট্রুথ বলছি।
All. You
Speaking, not saying.
my lord. Are you aware that if you make any statement which is false and false to your knowledge,
না,
it amounts to perjury? Are you aware of this?
জানেন এটা? আপনি একটা মিথ্যে কথা বলেছেন, আপনি কি সেটা জানেন?
আমি একটা মিথ্যা কথা।
Are you aware of
Not that.
that?
আপনি একটা ফৌজদারি করেছেন। আপনি একটা
I want to make him aware, no?
আপনি জানেন?
It is my duty.
আমি করিনি তো।
I am not done.
না,
It's not a question of whether you did it or not. Are
Um,
you aware of the fact that giving false answer would expose you to perjury? This is the question.
আমি এখানে কোনো মিথ্যে কথা বলছি না। আর
আপনি কি জানেন, আপনার জানান সেটা জানতে চাওয়া হচ্ছে।
আমি
সেটা জানতে চাইছি।
মিথ্যে সাক্ষী দিলে আপনার জেল হতে পারে, সেটা কি
হ্যাঁ,
আপনি জানেন?
আমি জানি।
I am aware of the fact that giving false evidence would expose myself to perjury.
Mr. Chaudhary, can you read English?
পড়তে পারেন?
আমি অতটা ভালো বুঝতে পারি না, সেই জন্যই বাংলায় বলছি।
পড়তে পারেন?
না, না, পড়তে পারেন।
পড়তে তো কিছু পারি, প্লাস আমার সঙ্গে আমার সঙ্গে যে কাজ করতো, যাকে আমি আমার আন্ডারে রেখেছিলাম, এগুলো সব তাকে দিয়ে করাতাম। তিনি আজকের দিনে নেই, তিনি অলরেডি মারা গেছে। তিনি মারা গেছে।
ওনার নাম বলতে পারেন আপনি? কি নাম?
শ্যামল বলে ছিল।
হোয়াট ইজ দ্য ফুল নেম?
টাইটেলটা মনে নেই তো, অনেক
Full
বছর
name?
আগের কথা।
When
মারা গেছে প্রায় আজকে হয়ে গেল প্রায় 7-8 বছর, 8 বছর আগে।
you remember? No.
হুম।
He used to do the work. You said
আমায় যা মেল টেল আসতো সেগুলো আমি দেখতাম, ওকে বসিয়ে কাজটা কমপ্লিট করতাম।
এই ইম্পোর্ট যে করা,
ইম্পোর্ট আমার তো সব ইম্পোর্টেরই কথা হচ্ছে।
ও বন্ধ বলুন। হ্যাঁ হয়নি? ও আচ্ছা, ঠিক আছে। क्या क्वेश्चन था? He used to assist you. He had more knowledge than you.
ওর নলেজ তো আমারই ছিল, আমার এখনো আছে। আর ইম্পোর্টটা বরাবরই আমি অন্য কোম্পানিরও আমি দেখি, আমার নিজের কোম্পানির আমি দেখি। এবং
What was? Sorry.
আমার নিজের কোম্পানি আছে তার।
What is the name of your company, Mr. Chaudhary?
Panorama Electronics Private Limited. Electronics Private Limited.
Private Limited. You are a director of the company?
Yes.
How many directors are there?
Three.
The gentleman about whom you said he died, was he whole-time employee of Sonic's plaintiff?
ওর কাজ ছিল আমার যেসব,
whether he was whole time?
না হোল টাইম না, যখন যেন আমি ডাকতাম আসতো, করে বেরিয়ে যেত।
No. Who are the directors? ঠিক আছে, আসলো করবো। Who are the directors of the plaintiff company?
অরুণ পোদ্দার ছিল, এখনো আছে অরুণ পোদ্দার। ডিরেক্টর স্টিল।
And who else? Can you name the directors?
অ্যানাদার ডিরেক্টর আমার নাম মনে নেই। আমার সবকিছু কাজ অরুণ পোদ্দারই আমায় দিত, সেই সময় কাজগুলো আমি করতাম। অরুণ পোদ্দারই আমায় সমস্ত কাজ করতে বলতো ইম্পোর্টের ব্যাপারে।
Is there any other person in the company who is aware of this import?
একদম আমিই জানতাম।
No other person?
না।
What about Mr. Arun Poddar?
He is the director of the company.
No. Is he personally aware of this import?
না, সমস্ত দায়িত্ব আমার ছিল, আমি কনসালটেন্সি করতাম।
All the responsibility was given to me and
This. Sure.
অরুণ পোদ্দারের সমস্ত কিছু কাজ, এই ইম্পোর্টের কাজ অ্যাজ এ কনসালটেন্ট হিসেবে আমাকে দিয়েছিল, আমি সেই কাজটাই করতাম।
as I was given the responsibility as a consultant, so I after the
Can you speak English?
English কথা বলতে পারেন?
ভালো না বুঝলে বলতে পারি না। অপোজিটের কথা যদি আমি না ভালো বুঝতে পারি তখন আপনাকে
I can speak if I not understand the content about
That is not, should not be your answer. Whether can you speak English or not?
বলতে পারি যেটা সেটা খুবই কম। মেনলি আমি লিটল বিট, আমি মেনলি বাংলা আর হিন্দিতে কথা বলি।
I am not so fluent in English in speaking English. I am rather fluent in Bengali and Hindi.
You can you read English and understand?
পড়তে এবং বুঝতে পারেন ইংলিশ?
আমি তো এই উত্তরটা আগে দিলাম
I answered this question
অলরেডি।
earlier.
Can you repeat the answer?
আবার বলবো।
আমি বলতে ভালো পারি না, আমি বুঝতেও ভালো পারি না, সেই জন্য আমি আমার যে অ্যাসিস্ট্যান্টকে রেখেছিলাম এই কাজগুলো তাকে দিয়ে করাতাম, ইনস্ট্রাকশন আমি দিতাম, যা মেল আসতো উত্তর আমি বলে দিতাম, সেইগুলো করতাম।
I'm not fluent in English. But I have appointed a person who is to look after
In
the
the-
matter.
In the college, you passed BSc. Was that in English medium?
Can I
ওটা ওটা বেঙ্গলি মিডিয়াম,
Bengali medium?
বাট বিএসসি সাবজেক্ট গুলো ছিল ইংরেজিতে।
But the BSc subject are in English.
ফিজিক্স কেমিস্ট্রি ম্যাথামেটিক্স।
I studied physics, chemistry, and mathematics.
Sir, this much today?
You-
This much today?
One more.
Much more.
Mr. Chaudhary, the suit which has been filed,
The suit which has been
who has signed the papers, you know?
paper গুলো কে সই করেছিলেন আপনি জানেন?
পেপার সই করেছে অফিসিয়ালি যে ডাইরেক্টর সে। এখন
Which
অরুণ পোদ্দার সাইন করতে পারে, আরেকজন ছিল আমার নাম মনে পড়ছে না, সেও করতে পারে,
The sign of
কারণ
the-
অলরেডি এই কেসটা প্রায়
Another
Whose name is not known to me.
নন ঘোষ টাইটেল হবে কি বলতে সঠিক বলতে পারছি না।
but I cannot say the exact name.
রাইট রাইট।
That's all. That is all, my lord.
PW1 is partly cross-examined. Further cross-examination is adjourned to, which will be convenient date.
Lord, see whatever.
Date down.
After first week of January.
21st January is okay? 21st. 21st January.
শরীর খুব খারাপ আছে, আমি আজকে এসেছি কিভাবে আমি জানি, আবার যদি 21 দিন পর আসতে হয়, অলরেডি 12-13 বছর কেসটা চলছে, চেষ্টা করবো।
Then we appoint some commissioner, advocate commissioner.
Let us see because it's only the cross-examination.
No, it will not continue. I will try to. Bashina answer. He's a good witness, he is answering. Mr. Chaudhary, we will not.
Mr. Banerjee, Lalnet Senior Counsel raised the issue that defendant number 3 is not in existence. Full stop. That issue may be raised in terms of appropriate application at proper time.
In terms of your lordship's last order, we'd already taken the issue in the form of an affidavit, taking exception to the general power of attorney and the board resolution.
Come with an application.
Very well. We come.
Because unless there is an application, I cannot pass any order.
Very well. Very well.
I'm grateful to you.
Great.
ধরো আগে এটা হবে আর item 14. Mr. Dotto, next time I will not wait for you. Finish your argument, I will close it.
So I think he can be excused because he's become a father very recently.
Father, good.
That is the cause for delay.
But he was in the court.
Now, on the last occasion, there was a direction upon me to file the written notes of argument. I have prepared the written notes of argument on my behalf, my lord.
With judgments given?
Yes, my lord. That's all are given, my lord. I will just hurriedly go through all the points, address all the issues once, my lord, and conclude my submission, my lord. Yeah, certainly. So this is a copy page. All reported judgments. This is a suit for specific performance where 4 plaintiffs have joined together for seeking a specific performance of 2 properties at Taliban, 215 and 217. Now, there are 3 defendants in the suit. Defendant number 1, defendant number 2, and defendant number 3. Defendant number 1 is a Japanese lady. Defendant number 2 is whom I am representing, and defendant number 3 happens to be a private limited company, which is a developer. Now, defendant number 1 is a Japanese lady. There is a settlement between the plaintiffs and the defendant number 1, and there's a decree with regard to defendant number 1. Now, only defendant number 2 is left over, who is contesting the suit, this suit. Now, my lord will kindly come to my written notes of argument. 2 dates, very crucial. The first date is on the 5th of August, 1987, when 6 documents were executed. 7 documents, all total, were executed. 1 development agreement and other 6 agreements for sale in respect of different shares of the property situated at 217 and 215 in NSC Bose Road, Tollygunj. Now, and the second date is the 5th December 1995, which according to the plaintiffs are the date on which the cause of action for the purpose of institution of the suit has arose. That's pleaded in paragraph number 21. Now I will proceed to deal with the issues, my lord. My lord, I will address your lordship first on issue number 8. Whether the suit filed by the plaintiff for specific performance of the agreement is barred by the law of limitation. Now, my lord knows that a suit for specific performance has to be instituted within a period of 3 months if a date is fixed, and if no date is fixed, from the date of refusal. Now, according to the plain case, the cause of action first arose for the institution of the present suit is on the 5th of December 1995, when the defendants wrote a letter to the plaintiffs about their refusal. Now, interestingly, this suit is instituted in 1996, but my lord will see from the list of exhibited document, that document has not come before the court. So this suit, so once that document does not come up, that the existence of that document cannot be shown. Now, the suit is, if we calculate, it's 9 years after the date of execution of the agreement. Now, 87 and 96, the suit has been instituted. So the suit is hopelessly barred by the law of limitation. In this regard, I would be relying upon a judgment. That's the first judgment which I would be relying upon. That's 2023 SCC online SC 1292, Shabbir versus Anjuman. I will be relying upon paragraph number 10 to 13. Here,
yes, you have quoted that.
Here, before the Supreme Court, the issue regarding period of limitation in a suit for specific performance came up for consideration. Honorable Supreme Court has held that according to Article 54 of the Limitation Act, it should be 3 years from the date of limitation. Limitation period cannot be extended by any means. That's the first issue. Now you'll.
So the suit is not maintainable.
Not maintainable first. Second point, I'll be addressing your lordship on issue number 9, whether the suit filed by the plaintiffs for specific performance of the 6 agreements for sale barred by law. According to me, the suit is completely barred by law. Why I say so? My lord will kindly take up section 31 of the FERA Act.
She is a Japanese lady, that's why.
Defendant number 1 is a Japanese lady, and section 31 of the FERA Act clearly puts a restriction on any if there is any transaction, you have to seek a consent and a permission from the Reserve Bank of India before a foreigner gets into any transaction regarding a.
Which section?
Section 31.
Section 34.
31. Restriction. I have quoted that section in my written notes. Restriction on acquisition holding of immovable property in India. No person who is not a citizen of India and no company other than a banking company which is not incorporated under any law enforced in India shall, except with the previous general or special permission of the Reserve Bank, acquire, hold or transfer or dispose of by sale, mortgage, lease, gift, settlement or otherwise any immovable property situated in India. And there's a judgment, my lord, I will be relying upon. That's a 2020-21, volume 19, SCC, page 629. I'm relying upon paragraph number 32, 34, and 50. 32, my lord, I'll just place 3 lines. From the analysis of section 31 of the 1973 Act and upon conjoint reading of section 47, 50, and 53 of the said Act, we must hold that the requirement of taking previous permission of the RBI before executing the sale deed or gift deed and failure to do so must render the transfer unenforceable in law. Now, your lordship will kindly come to paragraph number 34. In other words, until permission is accorded by the Reserve Bank of India, it would not be a lawful contract or agreement within the meaning of section 10, read with section 23 of the Indian Contract Act. Now, lordship will kindly come to paragraph number 30. That's a concluding paragraph. We conclude that the decision of the High Courts concerned, taking that view that section 31 of the 1973 Act is not mandatory and the transaction is in contravention thereof is not void or unenforceable is not a good law. So here the transaction has been entered without any permission from the Reserve Bank of India. So this agreement is unenforceable in law and that cannot be executed. Now I will be addressing your lordship on issue number 11 and 6. I will deal both this issue. The first issue is 11 is whether the plaintiffs number 1 to 4 were at all material times ready and willing to perform the said agreements, and whether the plaintiffs had the means and capability to perform their obligation.
These issues are in written statement.
These are issues are there in the written statement.
They take to WS.
These issues have been framed by order of 2014.
No.
Probably
Have you canvassed these points in your WS?
Yes, absolutely. I have indicated which paragraph I have indicated. I will just, lordship will kindly take up the plain first, then my written statement, then the evidence, and then I will show their deposition. The lordship will kindly come to the plain once.
Let me go through it.
Your lordship is at the plain to the written statement. Your lordship, I would first take up the paragraph 13 of the plaint.
এখান থেকে একটা কাজ করবে এই রেকর্ডটা পাঠাবে, কতগুলো জিনিস সেগ্রিগেট করতে হবে বা অ্যাটলিস্ট ফটোকপি করবে। একটা প্লেন রিটেন স্টেটমেন্ট ইস্যু, বুঝতে পারলে? করে একটা ফটোকপি সবগুলো করে কম্পাইলেশন করে আমাকে দেবে, ডিপার্টমেন্ট থেকে কুড়িয়ে নেবে। এইভাবে রেকর্ড দেখা সম্ভব না।
The old record of the Alipur.
ডব্লিউএস কোথায়?
We're looking for the plaint.
I'm looking for WS.
WS, my lord.
It should be in the record.
Yes, my lord. It is there, my lord. It is there.
Where it is there?
Well, I have checked. I took an inspection pursuant to my lord's leave. This written statement has been filed on 14th of June 2002.
এখানে নেই, এটাকে নিয়ে নাও। এগুলোকে সেপারেট করে একটা কম্পাইলেশন করবে। Yes.
I will kindly take up the plaint first, my lord, and then it will come to the written statement, my lord. Paragraph number 13, my lord. 12, my lord, is 11, 10, 11, 12 is regarding those agreements. And para 13, those are the alleged acts which the plaintiffs say that the plaintiffs have done. Kindly take up para 13. In performance of the said agreements for sale, various steps were taken by the plaintiffs themselves and not through the defendant number 3. Malvi, kindly take a note of it. Defendant number 3. Now, what steps? A, defendant number 3, on behalf of the defendant number 1, took steps for mutation. That's a step taken by defendant number 3, not by the plaintiffs. First. B, plan for construction. C, negotiations with the tenants.
Where is the written statement on behalf of defendant number 2 কোথায়? Other defendants এর হয়ে থাকার কথা। এইটা আলাদা করবে, সেগ্রিগেট করো। Where have you argued this point? Where have you raised this point?
I have dealt para number 13.
Written statement filed by?
Defendant number 2. They must be having.
Paragraph 13.
Paragraph 13 of the plain, I have dealt in paragraph number 10 of my written statement.
No, that is regarding municipal authorities.
No. First, my lord, paragraph number 13, the plaintiffs want to project.
With reference to paragraph 13 of the plain, this defendant reiterates so and so.
Para 13, my lord, those are the acts which the plaintiffs say they have done in furtherance of the agreement for sale, to show their readiness and willingness.
That is different thing. But applicability of FERA, of course, question of law can be raised at any time.
Is it?
Yes.
Now I am addressing your lordship on issue number 2 of the issues. This issue number 11 and 6. Readiness and willingness, the moot point in a suit for specific purpose. My lord, can you take up the plaint and then the written statement and then the evidence? He has to show both readiness and willingness together, simultaneously.
Evidence.
First, my lord will kindly take up the
যেগুলো
plaint.
বললাম যে প্লেন রিটেন স্টেটমেন্ট এগুলো সেপারেট করো জেরক্স করে।
Now, there is a list of exhibits. Exhibit.
The deposition and the exhibits, I believe, are in separate, my lord.
প্লিডিংস গুলো কোথায়?
আমাদের তো লিগালের ম্যাটার আছে।
These are exhibits. Anything pleadings? তাহলে ওইগুলো নিয়ে যাও। Exhibits.
No, plaint, my lord. What they have said, how I have dealt with, what is the evidence they have taken. My lord, can you take up paragraph number 13?
13 of the plaint.
First, my lord will kindly take up para 7. Those are the, my lord, agreements for all the agreements they have pleaded. Para 7 of the plaint. Now, your lordship will kindly come to para 13. Which the plaintiffs say that they have done in furtherance of the agreement for sale. What they have done, they say that we have mutated the property. Defendant number 3 has mutated the property, not the plaintiffs. Second page, my lord will see. They say that they have amalgamated the property. That's defendant number 3 has done. No act by the plaintiffs.
Have you put it in notes of argument?
Yes, absolutely, my lord.
All right, let me go through notes of argument. When it is there, I will go through it. If necessary, I will seek for your clarification.
Just place it, my lord, once, my lord, for my satisfaction.
Make it fast.
Yes, my lord.
Whole thing, if I want to put everything once again,
yes,
then that will waste my time.
No, I will not put. I will put everything in my notes of my lord.
That's all.
Then, my lord, regarding construction, that's by defendant number 3. C, that's regarding negotiation. That's by defendant number 3. Then deposited money for works. All this acts which the plaintiff mentioned in paragraph number 13 are being done by the defendant number 3, the developer, not by the plaintiff for purchase or procurement of the property. What they say in para 22 only, they say that we are ready and willing. But how they are ready and willing,
the particulars are not there.
Not there. My lord, I have, in my written statement, I have dealt with para 22. I have denied and disputed their readiness and willingness. Now, your lordship will kindly come to their evidence. The exhibits, my lord will get a compilation.
Exhibit.
My learned senior friend has prepared a compilation of the exhibits. Exhibit L2 Q. My lord will see letter to the Tolly Tax Department, letter to the Calcutta Municipal Corporation, certificate, registered undertaking, letter from the defendant number 3 to this and this, all this. No act done for procurement of the property. And in the entire evidence, my lord will not see that the plaintiffs have adduced and deposed that they are really willing and ready to purchase this property. One more thing, my lord, most interestingly, they have not shown any bank statement or their income tax return to show that they had the capacity to purchase this property. My lord, kindly see those exhibits. Nothing said. They have to show their readiness. Yes, no communication from the plaintiffs tendering the deed of conveyance, asking me to register the conveyance in their favor. Nothing said. Nothing. My lord, will kindly come to a recent judgment by Honorable Justice Banerjee and Justice Roy.
It is here.
Yes, my lord. Paragraph 45 to 51. That settles the law. That's the most recent judgment, my lord. 45. My lord will kindly come to the middle part of that for para 45. No
Have you
evidence has
given
been
this judgment? Where is that judgment?
2022 SCC online SC 840. Krishnamurthy versus Krishnamurthy. Para 45. Para 40, the respondent plaintiff has relied upon a notice dated such and such.
It is settled law that.
Yes, no evidence has been adduced on behalf of the respondent plaintiff as to how the respondent plaintiff were in a position to pay or make arrangements for payment of the balance sale consideration within time. The courts below also erred in not adjudicating upon the vital issue except to make a sweeping observation that given that the respondent plaintiff was a businessman, he had sources to arrange the balance funds. Now, your lordship will 46. It is a settled law that the relief for specific purpose, the plaintiff has to prove that all along and till the final decision of the suit, he was ready and willing to perform the part of the contract. It was the bounden duty of the plaintiff to prove his readiness and willingness by adducing evidence. Here, no evidence, no scrap of document to show that the plaintiff had the fund to procure or purchase this property. Not sure. Paragraph 40. In this case, the respondent plaintiff failed to discharge his duty to prove his readiness as well as willingness to perform his part of the contract by adducing evidence. Cogent evidence, acceptable evidence has not been placed to prove this readiness and willingness. Paragraph 48. It is therefore patently clear that the respondent plaintiff has failed to prove his readiness to perform his part of the contract from the date of execution of the agreement till date of degree, which is a condition precedent for grant of relief of the specific purpose. This court finds that the respondent plaintiff was not entitled to the relief of specific purpose. The respondent plaintiff may have been willing to perform his part of the contract. It, however, appears that he was not ready with funds. He was possibly trying to buy time to discharge his part of contract. Here also, in the present case also, my lord, no document, no bank statement, nothing shown to show that he was willing, he has a financial capacity to purchase the property. Now, your lordship will see para number 49, 50 and 51. In view
All
of
right,
the
I will
following,
check
this
it.
court is of the covenant.
So that is your third point. There is no readiness and willingness
Yes, sir.
for performance.
Performance.
Any other point?
Now, I will be relying about two more authorities, my lord.
That I will check.
19 and 17. Only self-serving statements will not do.
Concrete evidence should be needed.
Yes. My lord, Vijay Kumar, para number 6. He has to show readiness and willingness throughout.
That is settled law, age-old law.
Yes. That has been reiterated by the Honorable Supreme Court. There, my lord, the last judgment, my lord, Ritu Saxena, my lord, is the 2019, volume 9. Self-serving statements will not do. He has to bring documents. Here, my lord, the plaintiff adduced that he has a loan sanctioned. The Honorable Supreme Court said, no, this will not do. My lord will kindly come to para 15, middle part. Independent of such loan. My lord, got it?
Independent of such loan, there is a mere statement.
That the appellant and her husband have income of rupees 80 lakhs per annum, unsupported by any documentary evidence. Such statement will be of the nature of ipse dixit of the appellant and or her husband and is without any corroborating evidence. Self-serving statements without any proof of financial resources cannot be relied upon to return a finding that the appellant was ready and willing to perform his part of the contract. Here also, here the plaintiff also does not disclose what is his income. Nothing said. Now I will be addressing your lordship on issue number 7. Whether in the absence of performance...
Finish on the next date. Hard in part, adjourn to next date. If you are not able to finish, I will stop you.
I want to complete it today, my lord. I
5
came
minutes
ready.
more. Only
My lord
5 minutes more.
5 Then whether in the absence of performance of the purport development agreement by the defendant number 3, is the agreement for sale enforceable in law? Now, my lord will kindly take up the agreement for sale once. The agreement for sale, my lord will see, nowhere it is stated that subject to the development agreement. It is independent. My lord will kindly see.
That you have stated in the written statement, in your notes.
Yes, my lord. My lord will kindly see. I have stated that yes, the agreement for sale was completely enforceable in law in the absence of performance of the corporate development agreement, because the development agreement was between the defendant number 1 and 2 and the defendant number 3. It was the agreement for sale which was between the plaintiffs and the defendant number 2. It nowhere contained a stipulation that subject to fulfillment or performance of the conditions of the development agreement, then only this agreement for sale would be performed. It was not subject to, it was not that upon fulfillment this will happen. It was independent of each other. Moreover, that this suit is filed by the plaintiffs, not by the defendant number 3. The plaintiffs are seeking performance of the agreement for sale, not for the performance of the development agreement. Now, your lordship will kindly come to the next issue. Issue number 1, 2, 3, 4, 5. With regard to undue influence and coercion, I have adduced 7 and 8 of the written statement. I have said that I was only 18 at that point of time, and I did it under the undue influence and coercion of the plaintiffs and their advocate. And I have given an elaborate description while adducing evidence from 10 to 20, 10, 23, 42 to 40, 45, 46, 48, 51 to 53 and 57.
That was in your deposition.
That in my deposition given, and what are circumstances, how I was forced to execute those documents. Now, 2 more issues I would be addressing. Those 2 issues, my lord, those are not in the part of the issues frame. First, whether this present suit is abated or not. 4 parties have joined. Now, when the plaintiff number 1 came into the box and deposed, when he was cross-examined, he admitted that the plaintiff number 3 and 4 has expired. One in 2006 and another in 2003. No substitution, no recording of the death. He is aware. Now, he has 2 agreements. This plaintiff number 3 and 4. No substitution. Now, the suit has abated with respect to 3 and 4. Now, they have, while adducing evidence, they have purported to rely upon a deed of assignment, by which the plaintiff number 1 wants to show that the plaintiff number 3 and 4 have assigned their rights under those agreements to the plaintiff number 1. That's deed of assignment. My lord will kindly see that's exhibited. That's exhibited. I just give lordship. I just give lordship the number. That's exhibited. Deed of assignment is annexure exhibit U. Now, that first, I have 2 points over here. First, since 3 and 4 have died, those agreements cannot be enforced. The suit has abated with respect to 3 and 4. Second point is that, my lord, since this deed of assignment has not been pleaded in the plaint, and evidence without pleadings, a court cannot look into that with regard to 3 and 4, because the factum of assignment is not pleaded in the plaint.
This much, Mr. Datta.
And one more, my lord, and I will end, my lord. Whether the plaintiffs number 1 can depose on behalf of the other plaintiffs. First, my lord, no document of authorization, no power of attorney has been come forward, whereby which the plaintiffs 101 was authorized and empowered to depose on behalf of 3 and 4. 2, 3, 4. Moreover, my lord will see the entire deposition. He has not said that I am aware of the entire facts and circumstances of the case. He can depose, but he has to say that yes, I am aware of the entire facts. He should have a personal knowledge. He should have stated that, not stated. That's my all submission, my lord. I am praying for dismissal of the suit.
Argument on behalf of the defendant number 3 is complete. Fix.
Defendant number 2 is complete.
Defendant number 2 is complete.
At 28 or 21st,
Second week.
third week.
Third week.
Beginning of third week.
20th January.
Yeah.
20.
Fix 20th January for further argument.
আমাদের শেষ হয়ে গেছে আমাদের শেষ হয়ে গেছে
Grateful.
I'm really grateful. for being
But I appear.
Witness is there? Witness?
My witness is there. He is to be cross-examined, but the defendants are not appearing for the last 5 days. On the last day.
You are plaintiff?
I am plaintiff. On the last day, your lordship directed that it should be heard today and a notice to be given. They also did not appear on the last 5 days. I have served.
This was PW1.
No, this is PW2, 3.
3 used to be cross-examined. Thou?
My examination is over.
Affidavit of service filed by the learned senior counsel, Mr. Kaur, be kept in record. Full stop. This is service of notice in compliance with the previous order of this court dated 12 December 2024. Full stop. None appears for the defendant today too. For consecutive days, the defendant remain absent. Full stop. Therefore, comma, cross-examination on behalf of the defendant as well as adducing of evidence on behalf of the defendant stands closed. Fix the matter, fix the suit on.
Lord, it will be ex parte, my lord.
No, not ex parte. WS is filed. Okay, down now. 14 January.
As your lordship pleases, my lord.
14 January for argument. I have to consider the written statement. I may not consider the evidence because they have not adduced evidence, but pleading must be considered.
Lord, I'll indicate. The pleading is undue influence. Onus is on them.
That will be not proved, but I have to consider that this is the pleading, but this is not proved.
Certainly, yes.
In absence of evidence, I cannot say it is proved.
Because onus is on them.
Suppose they made an allegation. You may have admitted them. So in that case, without proof, that will go. That's why it is to be, it cannot be ex parte.
Certainly, my lord. But their allegations goes unproved. Therefore, my lord, once I tendered the document, the will, onus is on them to show
undue influence. Suspicious circumstance, you have to prove. You have to clear the doubt.
There is no issue on suspicious.
All right. I will hear argument.
Gotcha. I'm grateful to you, Lord.
So this is my probate application.
Where is the witness?
The witness is here, my lord.
Call him.
So this is PW2, my lord.
বাংলায়
English অসুবিধা নেই
That could be original of the will, my lord, with your lordship's permission. Can you produce to the witness? Then I'll ask directly from there, my lord.
Yes. Original of the will is to be, the will is to be, he is the attending witness or attesting
He's
witness?
the attending witness, two attesting witnesses. One of them died, the other one is untraceable at present, which is where your lordship had granted us liberty to bring on record, my lord, the attending witness as PW2.
I solemnly affirm
I solemnly affirm
whatever I depose
by the way of evidence
I shall speak truth,
I shall speak truth,
no part of it
no part of it
false,
shall be false
and I shall not conceal anything.
and shall not consider anything.
Your name?
তারকনাথ দত্ত।
Father's name?
ঈশ্বর চিন্তাহরণ দত্ত, লেট চিন্তাহরণ দত্ত।
How old you are? Age?
Is 61.
61. Occupation?
Occupation, I am retired person.
ঠিকানা বলুন, by address.
59/619 MB Road,
59 by
59/619 MB Road, বিরাটি কল্যাণ কোঅপারেটিভ। তারপরে কল্যাণ কোঅপারেটিভ, কল্যাণ কোঅপারেটিভ, নর্থ 24 পরগনাস, কলকাতা 51। আচ্ছা আচ্ছা,
বিলের কপিটা করুন। Mr. Dotto, what is this document that I'm showing?
This is a will of Rama Dattagupta.
Can you please tell the court what is the date of the said will and in which language has this been written?
2nd June 1995 and 2nd June 1995 and in English.
Mr. Dotto, what is your relationship with the said will?
Actually, I am just attending witness.
Mr. Dotto, do you find any signature of Srimati Rama Dattagupta on the said will?
Yes, I find signature of Rama Dattagupta of every pages.
In every page.
Of this said will.
Mr. Dotto, do you find any other names or signatures appearing on the document?
Yes, I can find that two attesting witness, Subroto Sengupta and Atanu Bhattacharya. And Atanu Bhattacharya, attesting witness.
Mr. Dotto, can you please tell the court what is their relationship with the said will?
Bhagwat, repeat. Oh. Yes, they are attesting witness of this said will.
Witnesses.
Mr. Dotto, can you please tell the court how do you know the signature of Srimati Roma Dotto Gupta?
Actually, 2nd June 1995, I was present there and saw the signature or Roma Dattagupta in presence of two witnesses, Subrata Sengupta and Atanu Bhattacharya, also in my presence.
Sign on the will, sign on the will on dated
2nd June
1995,
1995.
and the attesting witness also signed in my presence.
Mr. Dotto, in what capacity are you adducing evidence in the present probate proceeding?
Achha, 2nd June 1995, I was present there. And I saw the Roma Dattagupta had signed in this will, and also two attesting witness signed also this will in agents in my presence.
Mr. Dotto, sorry. Mr. Dotto, can you please tell the court what was the state of mind of Srimati Roma Dotto Gupta at the time of signing the said will?
তখন উনি সই বাংলাতে বলি এটা তখন উনি সই করলো উনি শারীরিক অবস্থা মানসিক অবস্থা খুব ভালো ছিল শান্তভাবে উনি সই করলো
At the time of execution of the will, he was in sound health and mind. Sound.
My lord, the will could possibly be marked as Exhibit A, my lord. Just prove the document. Tendering it, mark it as Exhibit.
Tender, you can tender it, but I don't think it's the right time to mark it.
Very well.
A lot of things are to be proved.
Lord, could I, my lord, at least direct a question, my lord, for him to encircle the signatures in that case?
No, unless it is marked. You have not asked the right questions as yet. Some right questions are yet to be asked. Come next day, think over it.
Very well. I'll come back. Lord, could I ask two more questions? Then I'll end. My lord. Two more questions, I'll come back. Two more questions. Mr. Dotto, can you please tell the court why the attesting witnesses have not come before in this proceeding for adducing evidence?
যারা এখানে উইলে সাক্ষী মানে আপনার সাক্ষী হিসেবে সই করেছে তারা এখানে কেন সাক্ষী দিতে আসেনি কোর্টে?
আচ্ছা অতনু ভট্টাচার্য has already expired and সুব্রত সেনগুপ্ত যতদূর সম্ভব ওনার ওইটা আমি বলতে পারবো না
Cannot say about any, cannot say anything about Mr.
সুব্রত সেনগুপ্ত
Subrata Sengupta.
Mr. Dotto, can you please tell your relationship with the testatrix, Srimati Roma Dotto Gupta?
অ্যাকচুয়ালি রমা দত্তগুপ্তর সাথে আমার কোনো সম্পর্ক নেই অ্যাকচুয়ালি I was attend on that day.
There is no specific relation with the testatrix, namely Rama
Rama
Dattagupta.
Dattagupta.
I was present there as a attending witness.
This much today.
I'll come back on the next.
PW1 is PW2.
PW2, my lord.
PW2 is examined in chief in part. Further examination in chief is deferred to. 15th Wednesday আমি probate রাখি না, either 14th or 16th 16th January.
Grateful.
Then put the
And the next.
Item number 20.
You are plaintiff.
My lord, I appear for the defendant, my lord.
I'm my lord for the plaintiff.
No, my lord,
Witness
for
is there?
witness action, my lord, the matter was fixed on 17th. The witness travels a lot, my lord.
17th January.
It was fixed on 17th of December, but your lordship was not there on that particular day.
Okay.
So, my lord, I was just humbly beseeching your lordship if it could be fixed anytime between 8th to 15th of January, my lord. He'll be there during that time.
14th January.
14th of January. Grateful, my lord. Deeply blessed.
On prayer of the learned counsel for the
Defendant.
it is DW1.
DW1.
Examination of DW1 is referred to 14th January.
14th January.
Grateful.
Lordship, may I?
Yes.
No. Mentioning
Yes. What is this?
that report, Lordship. I am filing on behalf of the official liquidator, Lordship.
When the matter is fixed?
A matter is not in the list, Lordship, but something happened that one shade had fallen. So we went for joint inspection and we
এটাকে একটা ডেট দিয়ে দাও। Report filed by the learned official liquidator be kept in record. Let the matter appear in the list, একটা ডেট দিয়ে দাও।
I'm grateful, Lordship.
জানুয়ারিতে এখন এই মাসে নয়। 17 জানুয়ারি। না লিস্টই দিয়ে দাও এই রিপোর্টটার জন্য। এটা রিপোর্টটা তো থাকছে, এটা 17 জানুয়ারি লিস্টে আসবে।
I'm grateful.
In this matter, madam, for the official liquidator, last question direction is given upon me to file report. A prepared malone hand over your lordship. Well, one thing the bank
Who is the applicant?
I am the applicant, my lord. This is my application for disbursement of the funds which were lying.
What this report is about?
This
the
is
status of the malone company.
in liquidation.
My lord was asked last occasion. Well, bank was taken time thrice to file their affidavit, and as per the ex-director of the company in liquidation, a sum of rupees 1 crore with them. They say no, they will willing to file an affidavit status. What is the? But till date we have not yet received. So bank be directed to hand over the amount. The bank is before your lordship.
For the bank, Union Bank of. On our last occasion, I asked my lord, your lordship, for time to file affidavit, but your lordship said, let this matter appear on that day. On that day,
Copy of the report is submitted by the learned official liquidator.
may I see of this be handed over.
Copy of the report may be handed over to the learned counsels.
Very well.
Report of the learned official liquidator dated 18 December 2024 be kept in record. Copies of the report may be handed over to the learned counsels. Now, what is in your report? Present fund position is statement.
And other status of this company.
That is
only 2 amount is yet to be received by the official liquidator. After receiving the 2 amount, which are ready to disburse the amount to the creditor of the company. In
1 crore 86 lakhs.
Yes. But
No,
two
it is
amount,
18 crore.
18. One amount is due from the bank, The sum approved is 1 crore.
Where have you mentioned this, the due amount? Page 12.
Yes.
PNB 30,000.
Yes.
PNB Brevon Road 16 something.
Something. Tomorrow Canara Bank, na? No, Union. Union Bank. Union Bank has not been mentioned.
My lord, may I seek a copy of the report?
Yes, I've given direction.
Yes.
My lord,
Give me one
for
copy.
what Union Bank was supposed to file their affidavits and serve copies in terms of the direction passed by the earlier.
Union Bank is not named here.
No, they have not yet mailed or filed that.
This is the statement of fixed. Oh, okay. This is fixed deposit. Union Bank is only banker.
No, my lord,
Please.
May I submit this, my lord?
One crore.
RBC action was initiated against the others, against the borrowers of the borrowers of the bank.
What is your status? Any fixed deposit is lying with you?
That amount was adjusted. That the 25% amount.
What is the amount payable by them?
1 crore 3 lakhs. Which
Where
was
it is mentioned? Have you filed any in your report? The amount recovered from them?
My lord, last question I mentioned that he submitted from the bank that we give a letter to them that has been annexed with my affidavit.
Asks the amount 25.
Please, one by one. Where is that letter?
It's here. My lord, my affidavit filed by the official liquidator at page, my lord, 10, dated supplementary affidavit filed by me, that is dated 4th day of September 2024.
EMD is?
Earnest money deposit, my lord.
That is at page.
Yes, I found it. We have demanded 1 crore.
Yes, that has been come to our knowledge from the ex-director of the company in liquidation.
Now, point is whether this is mentioned, included in your report or not.
No, report has not been, amount has not been received. Only request was made to hand over the amount. They asked, they will
must have calculated what amount is payable.
That has been mentioned in our letter, a sum of rupees, my lord, roughly 1 crore and odd.
Very good. Why have you filed this report then?
No, report filed by me. What is the present status? Except the bank and other letter have been issued to the ex-director of the company in liquidation. They filed statement.
What is the status? Just I want to know what is the amount of money lying with the official liquidator?
That has been mentioned, my lord.
What is the amount lying with different banks, whether fixed deposit or in savings bank accounts? Now, in that, is that statement here or not?
This statement is not the bank.
So you filed an incomplete report.
No, my lord, wrote a letter to the bank, say nothing is due. Only the ex-director of the company in liquidation intimated us. We then and then wrote a letter to the bank, hand over the amount. Bank say nothing.
So it is disputed.
Disputable. They file the affidavit or hand over. If they file the affidavit, whatever the status may reflect in the affidavit, we shall deal with them. If they not file, hand over the amount to us.
All right. So they are disputing that this amount is not due.
Before the liquidation, the amount was.
Come with an affidavit.
Yes, kindly give me time.
Apart from this, if we ignore this amount, then how much amount is in your hand?
Well, that have been mentioned in my report.
This 1688. This much.
This much. And two amounts.
No, this is with the fixed deposit lying with the banks.
Apart from that, this is with us and bank amount with the bank and other two amounts.
You have mentioned in page 11, 1861, something like that.
Right.
And another statement is 1688, so and so.
Well, main is annexure B at last page.
I understand.
12. 1 crore 68 lakh 85,700.
This is lying as a fixed deposit amount in different banks.
Different banks.
And what about this money? This 18 crore 861 lakh.
What is 18 crore?
18
crores. Yes. ভুল করেছেন এইটা বলে এটা
Receipt and payment account.
Receipt and payment account. এটা হ্যাঁ 1 crore 86 lakhs ভুল করেছে এটা এটা 18 crores টাইপে ভুল করেছেন এই টাইপটা টাইপে গন্ডগোল আছে কোড দিয়েছে মাত্র প্রফিট কি 2,97,000 কে দিয়েছে কাকে আমাকে তো 10,000 টাকা
No, I can't understand. You have received 18 crore 61 lakh something. It is in the left hand side. This is the receipt.
perhaps first page a typographical error.
So let me understand one thing. This is your receipt.
Receipt.
And your closing balance expense, you have shown 16 something.
16 something.
So what should be the balance? A minus B should be the balance.
Yes, that is, my lord, 1 crore 68 lakhs 85,700.
Where that is mentioned?
At page number 12. দেখি ভুল দিয়েছে ঠিক আছে
That is your interpretation, your oral interpretation. What is your statement shows? What does your statement show? Have you shown that this is the income, this is the expense? So the balance is the income net proceed?
Yes, yes.
That is not there?
1 crore 86 lakhs.
Left hand column, there is a figure mentioned in the left hand column.
This is the typographical error.
Come with a fresh report.
Yes, ma'am.
The learned official liquidated fresh core order is directed to file a proper statement of accounts with necessary documents.
Yes.
Full stop. The said report must contain
Actual.
the statement of bank accounts, fixed deposit, and other investments. Report shall be filed in this court on or before the returnable day. Let the matter appear in the list on 7th February.
One more, bank, either filed affidavit or hand over the amount.
May be granted in the
third time.
That is separate issue. Bank is directed. Which bank?
Union.
It is further submitted in terms of affidavit, in terms of supplementary affidavit by the learned official receiver.
Official liquidator.
Official liquidator, sorry. That is sum of rupees
approximately 1 crore.
Where is that affidavit?
My supplementary affidavit is here. At page 10, annexure B. In paragraph 2, it is mentioned, is informed EMD is lying with a bank for an amount of more than 1 crore since lying long time. You are therefore requested to refund the said EME, display company immediately to the office.
Submitted in terms of supplementary affidavit that more than 1 crore is lying with the Union Bank of India, Dharmtala branch, 8 Lenin Sharoni, Dharmtala Street, Kolkata 13. Full stop. It is further submitted that in terms of letter dated 9th August 2024, bank was directed by the learned official liquidator to refund the said amount. Full stop. The learned counsel for the bank is present. Liberty is given to file him affidavit giving the statement of accounts. On or before the returnable date.
I have a submission in this respect, my lord. My lord, there were two issues which were pending as my learned friend had said. One was the issue of collection from the Union Bank of India, where my learned friend has said that they want to file an affidavit. There was another money which was due and payable to be received by the official liquidator from the ex-director of the company.
The company went in liquidation in 2014. Up till now, the cash in hand which was there with the
That's why he is directed to file fresh statement of accounts.
my lord.
And
Is that subject to my
No,
lord's
if this
pleasure?
statement of accounts is filed, copies will be given to you.
My lord.
Then you come with an affidavit saying that this amount is lying there, why that's not in reflected.
Yes.
My lord.
In that case, I will wrote a letter to that. No reply has been given. You have to take step, file letter for direction before. Same letter was given
And
to
second
the.
thing, you can come with an affidavit asking the liquidator, official liquidator to recover that money.
My lord,
That you can do also.
my lord, the advocate on record and the ex-director of the company intimated by us in writing that hand over the money to us. Last date and expired in terms of the order passed by the company
you
court.
take steps.
Now we will file letter for direction before your
Yes.
lordship to realize this.
Absolutely.
Only this.
And if necessary, you file application.
That is letter for
Person
direction
direction.
before your
Yes.
lordship. There is of my lord and the official liquidator.
Very well. As it falls from my lord, I'll file a formal application request for a direction upon official liquidator to take steps.
On mentioning, you can file it.
I'm
Need not wait.
7th February.
Can it be a little earlier, my lord?
January.
In somewhere in January.
No, not January.
Wait.
6th February.
6th February. আমার নামটা বুঝবেন?
Lord, this is my application, my lord. Last occasion, my lord, I have also submitted a copy of the, my lord, the judgment of the Honorable Supreme Court of India regarding, my lord, the limitation. With regard to the limitation, my lord, this actually what was happened in this matter, the company went into liquidation on 31st January 2017. That was the winding up order. Then, my lord, the company, as per, my lord, the Companies Act 545 of the Companies Act 1956, official liquidator is required to, my lord, they file the miscellaneous application within
Let me go through this judgment. Give me time. Let me go through this judgment. Come on the next date.
Very good.
The learned official liquidator. Hard learned official liquidator in part adjourned to 17 January.
Well, I'm
16 January.
16 January. My lord, this is also my application. My lord, I am seeking direction from your lordships regarding the acceptance of the valuation report submitted by the valuer, learned valuer. If your
Where is
lordships
that?
kindly take summons for direction, prayer A, my lord, the valuation report has already been submitted before the
Where is the report?
assistant register, my lord, of the companies.
For sale of properties.
Yes, with regard to the properties, now, my lord, if your lordships kindly see order of this Honorable Court dated 21st December 2023 in affidavit page 18, Annexure D. Annexure D, that was the order, my lord, that application was filed before by the official liquidator seeking direction for appointment of impaneled valuer to value the assets and properties of the company in liquidation. It is submitted on behalf of the applicants that pursuant to the order dated 1st August 2023.
Yes, yes, I got it.
So, my lord, that valuation report has already
Where
been
is the report?
submitted, as I am told, informed.
তাহলে valuation report টা নিয়ে নাও valuation report টা নিয়ে ওটা next in place করো the valuation report may be placed before this court for effective hearing of CA 4 of 24.
Lordship will kindly record, my lord, that I have paid the valuer's fees. I am the petitioning creditor. There's a direction.
are?
I'm the petitioning creditor. I am
Shubham Capital.
I'm Shubham Capital.
Mr. Mitro, the learned senior counsel appearing for
Shubham Capital Private Limited.
Shubham Capital Private Limited.
The petitioning creditor.
Submitted that
Yes.
Fees of the valuer was paid by him.
Fee of the impaneled valuer. Impaneled valuer, because
Whatever that might be, fees of the valuer
has been paid by.
paid by him.
And
Let the report be placed on the returnable date before this court.
The report is with the registrar, I'm told.
Yes.
I have not seen it because I cannot see it.
No, that should be called for.
Yes.
Should be called for, your lordship will see it and then pass the necessary orders.
The matter will appear in the list on 29 January.
I'm deeply impressed.
This is my application, my lord. I'm for the official liquidator. Your lordship can
Have you put that in execution, Mr. Mitra? Have you put that in execution or keeping it idle?
Which one, my lord? That
That one?
That one, it is gone in appeal. And
Let them go.
decree should have been passed on admission. There was an amendment made. The lordship is talking about that matter where the amendment was there, Coal India matter.
The other matter.
That Coal India has gone on appeal. Not that. Then I don't. Up to the clients, my lord, we get the order, give it. The order is
Who
there.
is your client? You are the client. You are your client.
Oh, that matter. That matter, my lord, nothing has happened as of yet. It takes time. Your lordship knows, my lord, these things evolve through time.
Absolutely.
It's like a plant. It takes time to become a tree.
No, something are there which I cannot express
Yes,
right now.
which I also don't want to say in open court, but it takes time.
Yes.
I know that defamation one.
My lord, the summons for the directions made certain
My
innocuous
problem was,
spread.
Mr. Mitro, my problem was I was encountering my seniors later.
I did not know. I'm not meant to know and I did not know that's best. Certain things, my lord, ignorance is bliss.
No, that was my seniors letter that I encountered.
Your lordship dealt with it. It can be anybody's letter. Your lordship deals with it in accordance with law.
Yes.
It can be God's letter also, but it is in accordance.
I could ignore it. I could release it. I did not because I know I will not be biased.
I appeared because I was a party in that matter.
Anyway,
That done and dusted now. It is for others to decide.
that did not affect me.
I'm grateful to you. That is how ideally it should be. Ideally it should be, but we are not living in an ideal world. That's all I can say. Lordship sees everything that's going around. It's not ideal.
No mention. Nothing to be mentioned.
Nothing to be mentioned.
Nothing to be expressed.
Nothing to write home about.
Yes.
Like you used to say in a childhood days, nothing worth writing home about. And the Chinese have a curse. Chinese have a curse. May you live in interesting times. It's a curse in Chinese. May you live in interesting times. Because more interest there is, more problems arise. That is why you live in interest. May you live in interesting times. I thought that was not a curse. But now I realize the gravity of that statement. May you live in interesting times. Lord, I thank you, Lordship.
Your lordship kindly takes up the summons for direction. These are all the innocuous praise made by the official liquidator to conduct a fresh sale. Apropos the facts of the case is that earlier a sale was conducted and a report was also
Valuation
filed
report is there?
accordingly. Yes, my lord, the valuation report is with the assistant register, my lord. And that needs for fixing the reserve price, the valuation.
What is the valuation report?
The valuation report কোথায় গেল একটু ডাকো?
Valuation report is called for from the department for effective hearing of IACA number 10 of 29, 10 of 2019. Because I have to specify the amount.
Yes, my lord, for the reserve price, my lord. Because these are all movables for the selling of the gas cylinders.
Gas cylinders.
Yes. So earlier there was a, they have conducted a sale.
I have to know, actually, I have to allow your.
The advertisement, my lord.
No.
Because the reserve price is required for the.
Prayer D should be allowed first.
To the accessory to disclose and hand over the price.
Price
And
valuation
then,
report.
And then comes the prayer C, my lord. That needs to be
It should be
advertised.
prayer A.
A is for releasing that
It should be prayer A.
ought to have been, my lord. This is what they. But D and C should be given the priority because after this valuation report is disclosed, the reserve price is fixed. And then they will, not in the paper, but they want to distribute handbills and also
Prayer B of the application accordingly stands allowed.
D and C, my lord, or only D?
Only D for the
Only
time
D,
being.
only for the time being.
Because I have to say that you will sell in at that price.
The reserve price.
Reserve price.
Yes, my lord.
Unless I can see it, I
Yes,
cannot
my
pass.
lord.
In fact, you should write it in the reverse way.
Yes, ought to have been done.
D should be A. Let the matter appear in the list on তবে দেখো বলো
January.
January করো 27 January.
Deeply obliged. And the next one, my lord, that also pertains to the same company liquidation. That is item number 25. But it has become very, at this relevant point of time, it should be withdrawn, my lord. Because my lord kindly takes up the summons for direction. This is for the releasing of the security guards and also making the payment to the, because they have already been released. Because they were deployed by the official liquidator and subsequently released. So only the payments needs to be done. So until and unless the money comes to the coffer of the official liquidator,
Kept pending.
then let the matter be kept pending, my lord.
CA 12 of 20 এটাকে সেপারেট ইয়ে হবে CA 12 of 21 be taken up same matter.
Same company. Same company. Only the CA numbers are different.
We appear, let CA, this application, namely CA 12 of 21, appear in the list along with CA 10 of 19.
Yes, my lord.
On the same date.
Deeply obliged. May I file the status report? There was a direction for filing a status report.
The learned official liquidator filed status report dated 31st day of August. Why are you filing it right now?
Because there was a direction, my lord, but this matter did not appear in the list. So we didn't have the occasion to file it, my lord.
Do one thing, take it back, put a date, file, add something more. The learned official liquidator,
To file a fresh status report.
not mentioning this one, shall file a status report on or before the returnable date.